to mention for correction.
Correction, please hand over.
Expeditious hearing and interim stay, my lord. Expeditious hearing.
Yes, it is appearing in the list. So you want upgradation?
On update.
Please mention the urgency. Upgradation, please hand over the slip.
My lord, may I mention?
But please mention the urgency.
My
Some
lord.
of you are handing over the slips without mentioning the urgency.
My lord, may I mention one matter, the contempt application matter?
Contempt, please wait. Upgradation, please hand over the slip mentioning the urgency. But upgradation of motions only, not contested application. Please don't hand over the slips for contested application.
Contested application, interim stay has already been vacated.
Mr. Vadajaji, it's not.
Next date of hearing.
Yes.
Lordship, may I be allowed to mention the matter?
Please wait. Upgradation, please hand over the slip.
Lordship, may I be allowed to mention the matter?
Applications, please hand over the slip.
My lord, application for restoration.
Any application, please hand over the slip, including contempt.
Application for restoration.
My lord, contempt application.
Please hand over the slip. All applications, including contempt, please hand over the slip.
Lordship, may I be allowed to mention a matter for inclusion? For inclusion.
Inclusion of under the heading motions only,
My
not contested application.
Lordship, I'm mentioning this.
Please,
I'm sorry.
motions, please hand over the slip.
My lord, inclusion for motion, my lord. Inclusion for motion, my lord.
Motions, please hand over the slip.
This is application. I'm sorry. I mentioned this matter last week also. Lordship, will kindly.
Application for what?
Restoration. It appeared for the first time. I could not reach. It was dismissed for default. Kindly, Lordship,
I'll
at least let the matter appear,
It
Lordship.
will appear. It will appear.
Lordship. I spoke to my clerk, spoke to my lord's officer, Lordship. He said probably it will appear in August, Lordship. The next date is
August,
monthly list of August.
July,
I'm grateful.
not August.
I'm grateful, my lord.
Is your CO? What do you want?
Lordship, I had mentioned the matter.
What do you want, sir?
I want a date can be fixed so the matter can be.
Mention the urgency, please hand over the slip.
Lordship, the urgency is the.
Please indicate that in the list. I cannot remember. Please indicate that at the list. I will go through the
Can I
list.
be permitted to mention one matter for inclusion?
That's the
in the
system which I am following. I'm fixing dates, provided I am satisfied with the urgency. Please mention the urgency.
Lord, I'm praying for an inclusion in the list, my lord.
Please hand over the slip.
Lord, it is very urgent, my lord.
Motion.
Yes, my lord.
It's not in the list.
No, my lord.
When it was filed.
No, it was filed in the year 2024, my lord.
So now.
My lord, it has been heard one day. My lord, it was heard one day. My lord, thereafter it was directed to appear in the monthly list of November. Well, since then it is not appeared and we have mentioned several times.
Yes,
my
hand
lord.
over the
My
slip.
lord,
please.
under
I'm grateful.
compelling circumstances, I beg to mention this matter. My lord, tomorrow I shall be disposed. This is this matter where my lord the DRET was not there. My lord, the petition was as such. It was
This is the item number.
item number not in the list. On it was called on. The learned junior was there, Mr. Senior, and he was appearing. I was sought for my lord had directed as adjourned. My lord,
So that it was
my lord, kindly.
for time.
Kindly, my lord. It was under compelling circumstances.
That will not be a problem.
Urgency was my lord. My lord, kindly, my lord.
Be a ground.
Kindly, my lord.
I have my
Yes, my lord.
You was given a chance. The matter appeared in the list on the day you have mentioned in the presentation form. You pray for urgency.
bow down, my lord.
When you paid for an adjournment, then at that point of time there was no urgency.
That was on 30th. That was not today.
Yes. Please,
Tomorrow.
no.
May I have my lord's leave to mention, my lord, under compelling circumstances, my lord. My lord, the petitioner has challenged with your lord.
Sir.
My lord, upgradation, my lord.
Please indicate the urgency, hand over the
My
slip.
lord,
Yes, Mr. Chaudhary.
My lord, I'm a tenant. I've been resisting a suit for 10-15 years. I've convinced my client to settle and hand over possession. Any day, my lord, there's no urgency. Please, after 2 weeks, 3 weeks, 1 day as mentioned.
You have settled with the.
My lord, I haven't. I want to settle. I'm ready to hand over possession. There's a revision before your lordship.
Others for the other side.
My lord, I'll give notice if your lordship, my lord, gives it.
Talk to the other side. If the other side is not willing to that, then it has to be hard on merits, Mr. Chaudhary.
No, my lord, we'll bring him here and request your lordship to send it to mediation. I'll try and, my lord,
Please
settle.
talk to him. Unless he agrees, no use. If he comes and says no, I'm not willing to go to the
Please
mediation.
will request, my lord, kindly keep it in.
Please ask with the other side. Please have a talk with the other side, then mention.
I'll, my lord, speak to him personally and saying that your lordship has observed, I should.
Please do not put the court into an embarrassment. So if you want to settle, put the terms to him. If he agrees to that, then please come
Problem
and
is there
mention.
is no advocate, my lord. That's the problem. He's appearing in person.
Then talk to him, otherwise it will be difficult. Please don't take the name of the court.
Very well.
Otherwise the wrong signal will go.
Sir, may I have your leave to mention one matter for expeditious disposal since 2000, the matter is pending before.
Please hand over the slip. Appearing in the list.
No, my lord. It's not appearing,
Motion,
my lord, for inclusion.
motion,
Expeditious disposal, yes, my lord, motion.
motion stage. Please hand over the slip.
My lord, may I be permitted to mention,
Inclusion.
my lord, item number 43 of the today's list, my lord, kindly fix it, my lord, at 2 p.m. I'm leading.
That's not possible. Let me see how far I can reach. Yes.
Withdrawal of a civil divisional application.
Withdrawal of a civil division. You are the petitioner.
I am the petitioner.
Which item?
It's not in the list, my lord. There is stay operational, my lord. But I've got written instructions.
The withdrawal. Have you indicated in the list as withdrawal?
Yes, my lord.
To be mentioned, diye din.
My lord, may I be permitted to
Objection, no.
mention, my lord, this matter, item number 269 as updated matter. Kindly fix it on tomorrow. Day after.
Please hand over the slip. Indicate the urgency.
My lord, may I kindly have your leave to mention for inclusion in motion? Notice has already been sent
Inclusion.
for inclusion in.
Hand over the slip. I've asked you to hand over the slip for inclusion.
May I get your lordship's
Lordship.
leave to kindly mention one matter. Your lordship has passed an ex parte order, your lordship, in this matter, revision matter. The civil court proceedings has been stayed and it was about to come in the monthly list of June, but it has not come, your lordship. Kindly, it may be included in the list.
Please file an appropriate application. Yes.
Your lordship,
Kindly
this
will-
is,
May I mention one item number 1248, the interim order is expiring end of this month. Since Mr. Shorno Bhattacharya appeared, but I am taking little early steps. May it
So
appear as.
it has to be released.
Yes, may it appear as.
To be mentioned diye din for release.
may,
Upon mentioning here, upon mentioning the matter was at 2 p.m. on 12th June, but on that day, Mr. Rao saying, I know he leave the court. I paid for adjournment. Adjournment was there. Or thereafter, my lord.
Another advocate came. It cannot be done. Once you pray for an adjournment, it is adjourned.
In July monthly company.
It will appear in the July month.
my lord, may I kindly, my lord, the copy has not been served on us, your lordship.
Take appropriate steps, madam.
Your lordship, I'm mentioning, your lordship, let it be kindly come in the list. Your lordship.
Mentioning cannot be done. Take appropriate
We
steps.
don't know the advocate, your lordship. We don't know the details. your
Lordship, please take appropriate steps.
Lordship, it is the exceptional case, my lord. Widow woman, my lord. I am several times coming before
want?
lordship. Lordship, fix today or tomorrow, my lord, whatever. It is not habitable to stay, my lord.
Which is
long
the
I am,
item number?
lordship, item number 1568 already bottom portion on last occasion. 1568, my lord. In bottom portion, my lord, it will showing.
All right, please indicate that in the list, in the
Lordship.
mention slip and hand over the slip.
Lordship, kindly fix the matter.
1568.
1568 million in bottom portion of the list, lordship list, it is showing, my lord.
Yes, yes. Please indicate that and please. Yes.
In bottom
Yes.
portion.
It will be taken up.
Lordship, kindly taken
Sir,
up.
have you not seen the list today? It will be taken up.
That's why I am saying that.
Why are you
lordship,
mentioning that?
it is showing bottom portion, my lord. Kindly
Yes.
take up the matter, please, my lord. Otherwise, I am not.
4 p.m. these matters are being
Lordship.
fixed, sir.
Lordship.
May I mention?
I mentioned one matter.
The interim order, my lord. I have
Please
filed.
hand over the slip.
The matter is fixed on Friday in the lower court, my lord. It is expired
Sir,
on
why you did not mention before?
Friday was holiday. I have read my. That reason.
Yes,
Item number 546 running in the monthly list.
yes.
This is a matter, I have, the prayer is for expeditious hearing since.
Hand over the slip.
May I be
Please mention the urgency.
May I be permitted to mention, my lord, item number 1508 in the monthly list of June. This matter is in the earlier occasion obtained an order for expeditious disposal. But however, there is an unnecessary delay. So I kindly request you to keep the matter in the daily list.
Please hand over the slip.
Mentioning item number 1493 of the monthly list for
Expeditious
upgradation.
disposal.
Monday is the date fixed for PW.
Please hand over the slip. Indicate the urgency.
Mexican indulgence in respect of a listed matter. Item 73, my lord, it was mentioned before your lordship.
Yes.
I had handed over this slip. The date fixed is on the 7th of July.
Please hand
But
over
I
the
have
slip.
written that, but your lordship has given me the date on 15th of July, my lord. Otherwise, my
Prior
lord,
to that, not possible. All dates, if you verify, on all dates, the dates have been, matters have been fixed.
But in
It's
connection,
possible.
in connection with yes.
Cannot proceed on the basis of the dates fixed before the trial court. I've tried to accommodate, it's not possible.
Malad, only one more indulgence, Malad, in connection with 73, Malad, we have also challenged another order of the learned court below. Malad, let that be appear together, Malad.
Item number?
73 of your lordship's list, Malad. Malad, I have served
With that which will appear.
Malad, item number, this is not in the list, Malad. TO 1687 of 2025.
Please hand over the slip for inclusion. Mention that it is with that. Item number 73. Yes, yes, Mr. Trivedi.
Lordship, upgradation, I was praying for 389. This is running in my lord's list. Because 70
Combined or the supplementary?
combined. So,
Please hand over the slip.
Milord, I'm just mentioning.
You have indicated the urgency.
My lord, urgency, I have indicated 17th is the date fixed, execution.
Trivedi, it may not be possible because I think
My
up to 24th dates have been
my
given.
lord, my lord.
All dates will be after
We
24th.
are creatures of instruction. So we just mentioned it, my lord, I can understand.
Because of the last, up to I think 23rd or 24th, I could not exactly recollect.
My lord.
All dates have been fixed. It will be after that.
My lord will kindly not embarrass me, my lord. Just
So that,
I
that
can
is why
understand, my lord is working till
I
5.
can go by the dates of the trial court.
But I see, my lord, till 1:30, my lord is here, and then until 5, my lord is here. We are discussing in the corridor, my lord. That we are grateful for my lord's effort.
Excellent.
My lord, item number 126 of today's list, my lord, I have indicated the urgency.
Please hand over.
My lord, kindly to mention, my lord, 81 of my lord's today's list, my lord. This matter was heard on the 26th of July. But thereafter, because of paucity of time, the matter could not be finished. We could not finish our arguments, my lord. The matter has gone down, my lord. I was praying for upgradation of the matter. Item 81, I have mentioned the urgency.
Yes.
I'm grateful.
Lordship, item number 6 already disposed of. Your lordship stated for correction. I have not tendered, lordship. Item number
There must be some mistake for correction, it is appearing.
My lord, I beg to mention, my lord, seeking upgradation of 2 new motion matters, my lord. One,
Hand over the slip indicating, why are you mentioning individually? It's
Lordship,
not
I have
necessary.
handed over the slip mentioning the urgency. The original will is kept with the district court.
Sir, if
Because I
you
have
have mentioned, handed over the slip, I will only go through the slips. I will not be able to remember what you are saying. That's the difficulty. Yes,
Lordship, I have a difficult matter.
yes.
Lordship, my property is going to be taken over on 7th. And Lordship, possibly I'm covered by the latest Supreme Court judgment. And Lordship, if your Lordship
Matter is appearing where?
matter
Item number?
not appearing in the list, Lordship, as yet. I have filed it yesterday.
You have filed it?
Yesterday, Lordship. I've got
What is the
number.
date you have mentioned in the presentation form?
Lordship.
What is the date you have mentioned in the presentation form?
Huh?
Presentation from tomorrow.
Tomorrow.
Will appear tomorrow if you have filed.
No,
You have not yet filed.
You have not filed it.
no, leave চাইছি 4 তারিখে যাতে আসে।
Lordship, he is praying for leave so that the matter may appear on 3rd, on 4th.
Because
Lordship, on 4th.
Today we are on 2nd. What's the difficulty? File it, give the date of 4th.
7 তারিখে পেরিয়ে গেলে ওরা
Lordship, 7th, the matter is 7th, the possession would be taken over.
Give the date of 4th. Where is the difficulty?
they are not taking 4 তারিখ লিখলে নিচ্ছে না।
Approach them. If they say that they will not accept, please
এটা
come to
ফেরত
me.
পাঠিয়েছে। ফেরত পাঠিয়ে
Yes.
বলছে
Your Lordship may be permitted to mention a matter.
Please
The department
indicate.
is not accepting it.
they are
They are saying that we'll have to take leave for the matter to appear on 4th.
Leave. দুদিন আজকে তো 2nd, 4th. দুদিন তো হয়ে যাচ্ছে 48 ঘন্টা।
Your Lordship may be permitted to mention a matter in application for restoration.
Hand over the slips.
Your Lordship, we have mentioned on several occasions, kindly allow your.
Will appear in the monthly list. Yes,
Lordship, I'm handing over the slip for upgradation.
yes, call the list.
Your lordship, I'm handing over the slip for expeditious disposal.
Yes, call the list.
Number 1, your lordship, Mr. Shonak Bhattacharya is appearing for the petition.
Where is the learned advocate in record?
He is on legs before photo number 10, your lordship.
Ashwin, since I'm not inclined to take up this matter on personal ground, this matter stands in the list of this bench.
Reason I am
mention my lord for urgency as because
Yes, yes. What is this matter?
matter is, my lord, I have got one injunction order, my lord, from the trial court, and on that respect, my lord, they have filed one appeal misavailment, but the order of the misavail is specified, my lord, modified this some order. My lord. For that reason, I could not cultivate my land. This is the urgency of the case.
Yes. Where is the trial court order?
My lord, you have to kindly see trial court order 3435. Yes, here it was specified, my lord.
You are the plaintiff.
Yes, my lord, I am the plaintiff. My land has been recorded, my lord. I am the recorded owner, and after purchasing the land from the erstwhile owner, my lord, and after that, my lord, they are trying to trouble to my land. On that respect, I have filed this application, and on that respect, my lord, one injunction order is there. I am cultivating on the land, but in that against that order, they have challenged, my lord, the learned appellate court, my lord, Miss Appeal Court, my lord, they have specified the order. How on what basis, my lord, so kindly see paragraph, my lord, in the appeal order of the last page, where how the learned Miss Appeal Court has been find out this proceeding, this indication, my lord. The trial court in the written statement that it is the admitted position that Sajjad Mondal has three brothers, namely Ujjwal Mondal, Amjad Ali, such and such. It become Tawfiq Haq. It is further case that defendant has, by virtue of the sale deed and the deed number such and such, in respect of plot number such and such, to prejudice of the defendant, got the title over the same. How the appellate court has came to that finding, my lord? This is my submission. He have not gone through the order of the trial court, my lord. He has modified the order, and on that respect, I am suffering, my lord. The record of rights has been prepared in my favor, and all are in my favor. Yes.
Where is the order of the trial court?
My trial court page 34 onwards. Is kindly.
34?
Yes, my lord, 33 onwards. Starts from 33. Yes, kindly see 34, my lord. Peruse the petition under order 41, 31, 39, rule 1 and 2, CPC, read with such and such. On perusal of the instant petition, there are materials on record. It appears the plaintiff has failed to file the case in respect of the dag number such and such under Moja. In the case in hand, and the plaintiff is claimed to be owner of the possessor and dated Ato on the basis of title deed, and also relied by the learned advocate for the plaintiff at the time of hearing. Plaintiff has also filed the order sheet of case number such and such under section 50, and order of the bill or my lord, mutation case, my lord. And it appears that both the suit dag number and dag number under Moja, so no, now according to the defendants, whereas they are the co-sharer with the respect of the suit property along with the other several shares are matter of trial, and no definite conclusion can be arrived at this stage. Moreover, in this pleading, defendants have challenged the validity of the Khotian stands in the name of the plaintiff, in despite of the clear knowledge of the part of the defendants as existence of the LR Khotian. Accordingly, it has staged the perusal. The documents learned by the plaintiff, I find prima facie position of the plaintiff in respect of the suit property. And it also appears that if the defendants are allowed to dispose the plaintiff from the mentioned suit property, then the plaintiff will suffer, my lord. This is my case. So you have to kindly consider this situation.
What is the suit property?
Suit property, my lord, land, Kali land, my lord.
No, which plot? Where is the plaint?
Deed has been annexed, my lord.
No, what is the plaint schedule in respect of which property you are praying for injunction? 83 by 253.
On a plain, my lord, I have
and 83 by 257.
If I substitute, my lord, supplementary equity, my lord, I have annexed in the plain, my lord. In previous occasion, there is direction for Now, RS plot number 114. RS Khotiar number and plot number 83 by 253. Two Bata plots are there, my lord.
You are claiming title in respect of 83 by 253 and 83 by 257.
83 257.
And the defendants are also the owners of 83 by 257.
They are claiming, but they have not.
They have produced the deed. Where is the deed? They have produced the deed. Please kindly come to the appellate court's order. They have produced the deed.
Or in the trial court manner, they have not shows their supporting papers, my lord.
No.
In this respect, my lord, an injunction order was there.
Yes, but the appeal court has recorded that they have produced these two deeds. Wherefrom it appears that the defendants are the owners of, in respect of plot number 83 by 252 to 83 by 257. So 83 by 253 and 257 also they are the owners.
They are claiming what they have not right.
Produce the deed, sir. Where is the deed? They produce the deeds. They are not claiming. They have produced the deeds. They have produced documents. Show me your documents that you have title of the entire 83 by 253 and 83 by 257. They are claiming from 83 by 252 to 83 by 257 entirety.
Let's see, LR record of rights I have annexed in this
Please
application.
show me page.
What is your second? Page 17, my lord, Moinul Haq.
17. Not legible.
And 18, my lord, 83 by
Because
25.
you are not the owner of the entire property. You are the owner of the portion of that.
Portion of that, my lord.
How can an injunction be granted for the entire property?
That portion and the separated portion, my lord.
So that is to be decided. That is to whether the property is demarcated, whether we have exclusive title, that is to be decided in the
So you have
suit.
to kindly
How can
direct,
that be
you have to kindly direct the trial court, my lord, to expedite the proceeding, my lord, as
yes,
it is
yes,
possible.
that can be done. Yes, this application under Article 227 of the Constitution of India is at the instance of
One, original suit number 15 of 2022. Number 3 lines. It will be 364, title suit 364 of 2022. Actually,
Where is the trial court order?
that trial court. Milord, please see the last page.
Yes, Civil Judge Junior Division, first court. It should be first court.
First court.
And what is the other? The suit number is wrong.
Suit number is
It should be 364 of 2023.
2023.
It should be title suit, not
Title
original
suit,
suit.
right.
Ashun. This matter was directed to appear for yes. এটা কি আছে? হ্যাঁ, কি ফুল আছে? কি ফুল আছে এটা? হ্যাঁ? Does not কি হলো? লাগলো নাকি? Does not tally with the petition. কস্ট টাইটেলটা ভুল আছে বলছে। পিটিশনের সঙ্গে ট্যালি করছে না। কস্ট টাইটেলটা ট্যালি করছে না। ও হো হো, কারবালা ঘোষ। কি হলো, কেটে গেল নাকি? তাহলে এ করে দিল। এটা আসবে, এটা এ আছে, কস্ট টাইটেলটা গন্ডগোল আছে। কস্ট টাইটেলটা ওই শ্রীমতী নিহারবালা ঘোষ সিন্স ডিজিজ, হ্যাঁ, রিপ্রেজেন্টেড বাই অশোক কুমার। Same. It appears from the order dated 6th of May 2025 that there is a typographical error in the first paragraph of the said order, wherein the name of the learned judge of the appellate court was wrongly mentioned as double inverted comma the additional district judge first track FAST first track first court at Lalbagh, Murshidabad, instead of additional district judge first track court second court Lalbagh, Murshidabad. ঠিক আছে? Let such error be rectified. This order shall form part of the order. Yes, call the next matter. First title. First title. ওটা দেখে নিয়ে একবার কাস্ট টাইটেলটা কি আছে সেটা দেখে নিই, ঠিক আছে?
It will be this. Civil Judge, Junior Division, Second Court at Asansol. First paragraph, first paragraph, fourth line, and also at the last paragraph, where the direction is being given,
Yes, yes. What you have said?
But it will be Civil Judge, Junior Division, Second Court at Asansol.
Please take your first title.
First title. And then my mistake. It is well. But in body, it is written.
But first title.
First title,
So, cannot be changed. Order passed, take steps.
Second court.
First title, first preamble portion.
Date number 13, dated 4/4 passed by learned Second Court, Civil Judge, Junior Division at Asansol.
Yes, Ashun. It should be what? Second court.
Second court.
Order 6 rule 17 for plaint.
Yes, yes.
Plaint was rejected.
No. Order 6 rule
6 rule 17 application was rejected. Ashun.
Don't reckon my concern.
on 3rd of July. You have only paid for stay. So
Let the hear the stay
make
application.
a prayer, hear this application first, hear that application first. Though this matter is appearing, the learned advocate appearing for the petitioner.
The other opposite party. I have I have yesterday, my lord, I have prayed before your lordship that the matter may be referred to mediation.
My lord, I have taken instructions, my lord. With regard to mediations, my lord, my client is not that ready, but in case my lord says they go for a mediation.
Mr. Chatterjee, if your client is not agreeable, no purpose will be served.
My lord,
You are
what I,
saying not that ready, then how can the court send that?
my lord, only thing, my lord, if my lord directs mediation, let that virtually happen. She is in Shiliguri. Minor child is with her.
What is the
My lord, order impugned is, my lord, my application, my lord, challenging the jurisdiction court. My lord, has been, my lord, rejected, which has been, my lord, admitted by this honorable court. And, my lord, an interim order was passed.
So lordship kindly sees, my lord, section 9 application filed by the father before the Alipur court, my lord, has been now, my lord, they have mother is now in Shiliguri with the child after 9 years of staying together.
No, when the application was filed, where was the child?
My lord, Shiliguri.
At Shiliguri. But I
Shiliguri.
have
My lord, he admits jurisdictional court is Shiliguri in
factually
his
did not
objection.
admit. But whether, my lord, I have a judgment of a division bench judgment of on the same issue. If your lordship kindly considers it,
My lord, the parent, my lord, is that
my lord, one judgment of this honorable court, a coordinate bench passed by my lord Justice Deepak Pada.
I'm extending the interim order. I'm fixing this
If
matter.
your lordship kindly sees the judgment, my lord, it's a mixed question of fact and law, and on the only on the date of filing. If your lordship kindly sees one paragraph only, 29 and 31. There are other paragraphs also. Sorry.
29.
29 and 31 paragraph. 2024 SCC online, Allahabad 1610.
ICC.
SCC online, Allahabad 1610.
1610.
Facts are not disputed, my lord. Here.
Allahabad.
Let it be a preliminary issue as to whether
Preliminary issue.
Where is the finding of the learned trial judge?
my lord, learned trial judge has relied upon a
Kindly takes up the impugned order. My lord will find the findings or the reasoning part.
What is the date of the order?
The date of the order is 9th of April 2024.
20th?
9th of April 2024, order number 8.
Of April.
Order number 8, my lord.
9th of April 2024.
Lord, the certified copy.
Certified copy, plain copy.
Oh, sorry, I had a bunch of certified copy.
The can, the volume of the can, I thought that is the civil division.
And this revisional application was filed after 5 months. No explanation why there was any. No, I know that there is no section 5 is
follow that. I'll follow that in your matter also.
No, my lord, at least some explanations.
Yes, I will remember that.
And my lord, the Milord, the reasoning, Milord, I find, Milord, only one line once on summary inquiry. Milord, the penultimate paragraph above that.
Mr. Chatterjee, if an inquiry is necessary, it cannot be under Order 7, Rule 11. So you file an application under Order 7, Rule 11. I direct the
Milord, this is order under Order 7, Rule 11 itself. This order was passed.
In Order 7, Rule 11, an inquiry can be made.
Now, Milord, if from the Milord Riju Maju, which is the parent judgment, and all courts have been following that, Milord, the question which has been cropped up in Allahabad court, Milord, has also cropped up in previous judgments.
Riju Maju has been considered.
Well, a question of fact.
No,
Milord,
Milord,
the expression says ordinarily deciding.
There are two parts in Riju Maju. If my lord considers Riju Maju,
yes,
Milord, one question is of law and one question is of fact. Milord, Riju Maju says if from the pleadings, Milord, it is clear that the parties have absolutely cleared the intention that he will be residing, that it's not a casual stay. Milord, this is a question of law. But from facts, if it is said parties are not clear, then it's a question of fact. Milord, here, Milord, when he files a petition, he says, I went Shiliguri never to return back, and the jurisdiction lies with Shiliguri court. And in the objection to my written order 7 rule 11, he specifically states, I am permanently residing there. Where my child is studying in Shiliguri in school, and Milord, the Shiliguri court is having jurisdiction. Then Milord Rijumaju comes into play as to the question of law. Milord, this is no more of question of fact.
In my judgment, what I have
This requires consideration, Milord. I tell you, Milord, kindly keep.
because
Milord, I have gone. Rijumaju also says, Milord, has also vividly described what's ordinary residence and where from the intention, which is question of law.
my lord, your lordship, the present judgment I have handed over, my lord, it has considered Rijumaju. If your lordship sees paragraph 15 of my judgment, it has considered Rijumaju and then
Paragraph 15.
paragraph 15. My lord. In Rijumaju,
It will, Milord, that is the parent. Milord, I have brought, that's the parent decision on that line. Milord, kindly takes up.
All right, I'm extending, I will keep it.
kindly fix a date if it comes, because by 2022, my lord, the father
Thank you. When this matter is taken up for hearing, Mr. Ghosh, learned advocate appearing for the petitioner submits that the dispute between the parties have been settled amicably out of court. He further submits that the disputes between the parties have been amicably settled out of court. First up, he further submits that the petitioner has instructed him not to proceed with this application any further. First up, in the light of the submissions made by Mr. Ghosh, learned advocate for the petitioner, CO number such and such stands dismissed as not pressed. Yes, next.
Your Lordship, for the opposite party. Your Lordship, before the matter, Your Lordship, the maintainability part is required to be taken into consideration once. Item number 15.
It is fixed for
15.
orders.
Yes.
today, For orders.
Now you are coming with the maintainability.
Yes, Your Lordship, I have got something, Your Lordship, to identify. Your Lordship. Kindly once, Your Lordship, thereafter.
Lordship, then.
Then
Yes, I just correct that.
For the reasons as aforesaid, CO 359 of 2025 stands dismissed. Accordingly, the application stands disposed of. There shall হ্যাঁ কোনটা এটা তো অর্ডার হয়ে গেছে
জজ সাহেব কি বল
পাঠিয়ে দিচ্ছে চেম্বারে পাঠিয়ে দিন
ওইটা নিয়ে যেতে পারি আমি নিয়ে দেবো অফিস খারাপ হবে
So both will get the order in the server in course of this day.
conclusion oh not this boss.
This issue was actually required to be decided. There is one division bench of justice, IP Mukherjee presiding. That is also, it goes to an extent, but then does not decide the issue. So once your lordship decides,
I've tried to decide it in my own way.
of course, certainly. At least after this, it either has to be Supreme Court or this judgment will follow. My lord, this repeated application before the trial court, multiple applications before several courts. In fact, there's one more in your lordship's list.
Another
Item
87.
87.
can be disposed of in the light of this.
Well, let that remain. The time, please.
Yes,
I wish I could appear.
1-6.
For orders. He's here.
Yes,
Mr. Day is absent, my lord, due to his illness.
My lord, hearing concluded. Your lordship keep it for orders. Can we remember that?
he wanted to make some submission.
If
Second
order
day.
is passed, I am not. If order is passed, I am not objection, my lord.
You have concluded your argument.
Yes, already previously all
One first day, he took time after my conclusion to say something. Thereafter, he concluded his submission.
Then why it is for us today?
My lord, forget that. My lord has to deliver judgment. That's why it's for orders.
I've forgotten. I thought that
So much pressure
I thought.
going to happen. This is, my lord, this allowing
Also, please remind me because the facts.
order 6 rule 17.
Oh, prior suit.
He was
All right.
then can you make it CAB then? That will be better. If your lordship does not require any assistance.
Not CAB.
খোলা চলে যাবে।
CAB is difficult. আজকে কি বার মঙ্গল বুধ সোমবার রেখে দিন তো অর্ডার
Again for orders.
নো ফার্দার সাবমিশন সো আই এম রেকর্ডিং দ্যাট
Yes, can
আচ্ছা দেখি আগের দিন দেখি একটু অর্ডার রেকর্ড করা ছিল কিনা yes only your submission was recorded
Then
that
he
is
took
my
time.
last
No, then he took time. The following day, he make his submission.
the order was passed on 19th of June. This is the last order. On that date, heard Mr. Basu. Oh, opposite parties were also heard.
This was second day.
ঠিক আছে সোমবার দিন রাখুন as for orders. Any recording is necessary, Mr. Basu?
He is here, he will not pay, he told me already, so no recording.
Yes. Yes, call the next matter.
name for the petition of
Yes.
My lord, there is a report from.
This was for expeditious hearing.
Yes, my lord.
The records were not traceable. The report has come. They have sought for 1 month time to trace out the records. So I'm directing them.
Reconstruct the record, my lord. I have a certificate.
I'm directing them to trace out. If cannot be traced out, to reconstruct and to proceed. Ashut. This application under Article 227 of the Constitution of India is at the instance.
You send your lordship's order dated 9th of June 2025. It was for the report.
So the appellate court has said it was forwarded to the trial court.
Time and again, number of
Now it
occasions.
has come to the appellate court.
Now it has
That is
come
the,
to the,
that is the report.
but your lordship will kindly direct the lower appellate court to dispose of the appeal as early as possible, because I obtained the decree in 2017 and I have been
this application under Article 227 of the Constitution of India is at the instance of the respondents in the appeal. You are the respondents in the appeal.
I am the respondent in the appeal.
Is at the instance of the respondents in title appeal number 131 of 2017, praying for a direction upon the learned judge 9th court, 9th and learned judge 9th being civil court at Calcutta to dispose of the title appeal expeditiously. To stop, in view of the order sought and proposed to be passed, there is no necessity to direct issuance of any notice upon the opposite party. First of all, however, the learned advocate on record of the petition shall be obliged to forward a copy of this application along with this order upon the opposite party or upon the learned advocates representing the opposite parties before the learned trial judge. Now, before the learned judge of the appellate court, first appellate court. First up paragraph from the order dated 7th of March 2025, it appears that the trial court records were sent down, were sent back to the learned trial judge as the record was not complete.
But kindly add the word defect-free trial court record. Some of the orders, there are
some orders cannot be traced out. That is the report.
they have mentioned what are the orders.
So they will
And the
proceed. I am
direction also-
directing to proceed with that.
My lord,
Otherwise, the appeal cannot be heard.
my lord, my lord, my lord. I have to.
This court, by an order dated 9th of June 2025, called for a report from the learned judge, 4th Bank Presidency Small Causes Court at Calcutta, entitled appeal number such and such as to whether the defects in the trial court records have been removed. And the directions contained in the order dated 7th of March 2025 entitled appeal Yes, Mr. Mukherjee.
But I sent, my lord, but track report appears, my lord, the item had delivery dispatch, my lord.
Only dispatch, service not complete.
Not complete. Only thing, my lord, can you remember this matter, my lord, that
The records have been sent down. That is the. So now you have no difficulty.
but that's true. But they will again say before the court below that because what happened, my lord, I'm telling that a commissioner's report has been accepted in a suit for declaration injunction. But initially challenging that report, I came up before this court. This honorable court set aside the order and appointed a fresh commissioner because the earlier commissioner.
I am directing the civil division application to be disposed of without calling for the trial court records. That ends the matter. You raise all points there.
From the facts itself, it will appear that your lordship knows 115 capitally after the amendment from 1st July 2002, my lord. This is not
Go
mentioned.
there one day, apprise the provision of law to the land.
Date is given, my lord, after 3 months, 4 months. Kindly see, my lord, the 4th June 2025, next date given 4th September.
September is not very far off. Adjust your diary accordingly, go on that date. Apprise the learned judge of the provisions of law. This application under Article 227 of the Constitution of India is at the instance. Mr. Mukherjee, any purpose will be served. You have sent, but the service is not.
May I just request one thing? If you lordship kindly keep it next Wednesday. In the meantime, if my lord, the acknowledgement card or the track report, otherwise they will say your lordship directed to serve copy.
Mr. Mukherjee, learned advocate appearing for the petitioner submits that pursuant to the order dated
Pursuant to the order
25th of June
Yes, my lord.
2025, the copy of the civil division application was sent through registered speed post with acknowledgement due, but till date the opposite parties, but from the track report it appears that the opposite parties have not yet received the same. If a service filed in court today is taken on record. First up paragraph, pursuant to the order dated 25th of June 2025, a report has been filed by the learned additional district and sessions judge, second court at Hooghly, dated 10th of June 2025, wherefrom it appears that the trial court records have already been transmitted in compliance with the order dated 25th of June 2026 passed by this court. First up, pendency of this civil division application shall not preclude the learned additional district judge second court Chinsura district Hooghly to proceed with the hearing of the application under hearing of the civil division application filed under section 115 capital A of the Code of Civil Procedure.
But this will be a problem because
without insisting for the trial court records.
But this will create a problem because my lord, if your lordship make this observation, but I will take the maintainability point. But instead of my lord, let them come in their presence, my lord, by this time I have already filed the application for maintainability. Kindly keep it, my lord, next Wednesday, my lord.
Yeah.
No. In the court below.
Yes.
Therefore, your lordship has offered.
I have said to proceed with the hearing.
And next date is September in the court below. If your lordship keep it on next Wednesday, by this
তাহলে ওই পেন্ডেন্সিটা কেটে দিন, কেটে দিয়ে লিখুন list this matter under the same heading. Fifteenth of July. No, sorry, 16th of July.
Grateful.
If it is service taken on record. Yes, call the next matter.
May I please, your lordship? I appear for the petitioner, your lordship.
Yes.
The petitioner is the mother, opposite party in an Act 8 proceeding filed by the husband for custody and guardianship of a minor girl child. My lord, the impugned order is order dated 12/6/2025, whereby what has happened, the record, it was an off date. একটু বলে দিন সবচেয়ে ভালো হয় মিলর্ড হ্যাঁ ওটাই
You have challenged the order dated 12th of June.
12th of June. Milord, there is another pending CO before your lordship's court, Milord. If both the matters, I'm also praying for
This
that.
matter has nothing to do,
Milord, it is
police will not go provided you,
Milord, the difficulty
disposing of according your
there is
submission.
one difficulty, Milord, there is one difficulty, I tell your lordship. Here, in that other CO, what has happened, initially, an order for interim visitation was passed in favor of the father. There, it was directed that the child would be produced before the court on the first and third Saturdays. Thereafter, a modification application was preferred by the husband.
Sir, unless that is modified or varied, please comply
has
with
been
that.
modified.
Police will not interfere.
What is happening?
This is only, you have challenged, the scope of this civil division application is only that the police was directed to produce the minor.
Minor.
So now you have complied with, nothing remains in the.
That modification, what has happened, the court has directed for the minor to be produced in the house of the petitioner.
That I will consider when that application comes.
Milord kindly takes up the medical, the child is going through, going to a child psychiatrist. There, it kindly takes up page 60 and 62 for once, kindly.
I will consider that. This is the scope, Ashul. This application under Article 227 of the Constitution of India is at the instance of the
my lord, in this matter, that I am appearing for the opposite caveat or opposite party.
And I am for the
Have
petition.
not been served.
No, I have been, sir, my lord, we are also instructed to challenge the same order.
What is the impugned order?
Allowing an application under section 7(2).
7.
Allowing an application under section 7(2).
2 of the Original Premises Tenancy Act.
Is the plaintiff
Is a defendant, a tenant defendant.
allowed?
According to him, the quantum which has been area rate that is challenged, and according to us, 7(2) cannot be considered at all on the face of the record. Admitted rate not been deposited. That
No,
is
admitting this, I'm keeping it.
we are also challenging the same manner. It can be hard together, my lord. Tuesday, my lord, please. Tomorrow, is it probably today? It will be affirmed.
Your lordship to the operating procedure. What happened in this matter, my lord? Just indicate, my lord.
Where is that? Where is the impugned order? You have annexed the evidence.
Certified copy, my lord. Certified copy.
Certified copy, you have annexed the evidence also.
22nd April
Yes, now I have got.
My last question. What happened, my lord? My lord, initially, my lord, petitioner was inducted as the tenant by the father of the
1,41,304
41 was the area amount.
by 2 easy installments.
And the later question, my lord. But the adjustment of the adjudicated rate of rent with the renovation cost of rupees Ato and amount of Ato is as salami would be left open for adjudication at the time of trial. My lord, what happened, my lord? At the time of initiation of the agreement, my lord, time of execution, my lord, the plaintiff, my lord, petitioner, my lord, tenant, my lord, given a sum of rupees 4,50,000 as a salami. My lord, in presence of.
You want that point to be decided now?
7(2).
My lord, if it is.
No, if you want, yes.
My lord, if it is in.
The trial court has kept it open.
That is,
if you want, then yes, I will decide that.
I will leave it to your lordship, but my lord, my humble submission.
That is the only point.
No, my lord, the calculation amount, the amount is also not calculated properly, my lord. If I may take your lordship, my lord, to the previous page, my lord.
Yes.
My lord, here, my lord, initially the admitted position, the rent was receipt was issued. 500 rupees was usually the petitioner was depositing the rent to the rent control and also the civil court to a tune of rupees 500 per month. But it is admitted position. My lord, as per the agreement of 2000, my lord, it should be enhanced after 5 years, 10% enhancement would be made. But accordingly, it has been rightly decided by the trial court below that it will be decided that presently from 2016 onward, when he refused to take the rate, my lord, from then onwards.
Yes, Mr. Rai, what is your challenge with regard to the minimum?
Page 40.
14.
40.
40.
The application under section 7(2). Oh, the count token আছে না? ওদিকে আছে দেখ। Paragraph 2. Paragraph 4.
Paragraph 4, yes.
That after demise of Sunil Chakraborty, the plaintiff, despite having agreement, the plaintiff number 1 used to issue rent rupees 500 per month against payment of rent of rupees 1,200. So transaction is 1,200. I issued rent receipt of 500, be as it may. So what is the admitted rent tendered? Motor file.
Sorry, it has been.
So according to you, it is 1,200.
1,200. It is their admission. Last paid.
Why do you say 7(2) is not maintainable?
Because they have not deposited that amount. They deposited the amount at the rate of 500. This is the admitted. And admission, my lord, I draw your attention where the admission is.
My lord,
Madam, can you turn to?
And they have deposited at the rate of 500.
But it has been admitted, my lord. My lord, can you look at the observation made by the.
Your admission is 1,200. Your admission is 1,200 you have paid.
My lord, it isn't paid, but my rent receipt was issued at the rate of 500.
According to you, that is the dispute. You have said, though you have paid 1,200, but they have issued 500. So according to you, the rate of rent is 1,200.
My lord, it has been paid, my lord, to the tune of rupees 500 deposited. My lord, now, my lord.
That is so. According to you, that is the
dispute. My lord, it is not disputed. My lord, I have not disputed that I have not paid 1,200. It is. I have paid 1,200. My lord, can you have a look at the observation made by the trial court? My lord, can you have a look at one look? My lord, this 1,200, he have received a payment till 2016. He have made payment of rupees 1,200 per month till month of March. My lord, can you have a look at once, my lord? My lord, can you have a look?
This matter is taken.
My lord, kindly.
When this,
My lord, can I look at the calculation once? My lord?
when this matter is taken up for hearing, Mr. Royal Honored Advocate appearing for the opposite party, landlord, opposite party landlord submits that he has instructions to challenge the same order by filing a civil revision application. First of all, he further submits that the civil revision application proposed to be filed by the opposite
this
party is expected to appear in the list
On Tuesday. Monday
in
is the
course of the next week. First up, list this matter. Tuesday it will appear.
Monday I will file, my lord, after obtaining a short service, so it can be, he will not be prejudiced. Because Tuesday, Monday is the common list. Tuesday, if you lordship, I can put the date on that. I could date white even yes,
Because in all matters, short service, Mr. Rai may be because now scanning and other things is to be done. Certain urgent matters, I have asked them to.
That is why Wednesday, Thursday, as your lordship.
Give me your choice.
As your lordship, well, we have no choice.
It's your choice.
As your
Accepting short service any day, give me a date, I will.
Wednesday or Thursday, as your lordship, please.
Thursday.
As your lordship, please.
Thursday will be 10th.
10th.
Is expected to appear in the list in course of the next week. ওইটা রেখে দিন তারপরে লিখুন list this matter under the same heading on 10th of July 2025.
Next date is not given, my lord. I will also take information. The next date is not there because
Please mention the date of 10th. Otherwise,
yes, that is why.
If it is service filed in court today, is taken on record. Yes, call the next one.
I am for the disposal of the matter.
What are the grounds? Accepting default. It's the only ground.
Reason recovery is also there.
Fighting.
My lord, can you consider 1 month?
Expedited disposal.
1 month. Rent manner was Mr. Strucker by delivery of defense. The judgment I am armed with the judgment. I cannot lose both the times.
What can be done? The statute is such.
That is what, my lord, at that point of time, I was the losing side, my lord. At this, I'll try my level best to overcome.
The expeditious disposal of my matrimonial suit, my lord. I am the petitioner, my lord. Petitioner wife.
Husband of the wife.
Wife, my lord. Wife petitioner, my lord. My lord, from 2023, date for examination in judgment plaintiff witness now 2023, my lord. Kindly come to my lord. Order number 15, my lord. My lord, dated my lord 4/8/2023 till my lord 17/6/2023. Same position, my lord. 2023 to 2000.
How many resolutions the local bar association has adopted?
I do not know.
You do not know. Order sheet says so.
Yes, order is
then. What's the fault of the presiding judge?
And others, my lord, PO is late, my lord.
You are taking a resolution. You have chosen not to appear. Dates have been fixed. I will ask the learned judge to proceed in accordance with law, even if there is a resolution. You agree to that? I will direct that. The learned judge will be having no difficulty. You are taking resolution, you are not appearing, coming with 227.
No, my lord, I filed, my lord.
10th of March, there was a resolution.
3.
Yes.
Kindly
the PO 18th of June 2024, there was a resolution. 24th of April 2024, there was a resolution.
Petitioner is suffering, my lord.
Yes.
Initially, when husband appeared,
6th of December 2023, there was a resolution. So you undertake to appear, even if there is a resolution, I will direct expeditious hearing. Give that undertaking that will appear, even if there is a resolution.
I am not in court below, my lord. I am not in a court below, my lord. Some, my lord, kindly see, my lord, the court is vacant. There, my lord, 2, 3.
Yes, cannot be done.
My lord, kindly see, my lord. Order number 23, order number 24, my lord, kindly see, my lord.
It's at the examination of PW2. Ashun. This application under Article 227 of the Constitution of India is at the instance of the wife.
2020, my lord, it is pending, my lord. I'm the wife, my lord. They have thrown out from the.
How many dates? I have shown you 5 dates. You have And due to resolution, you have not attended.
Order is 25, today is 26.
This is 5 dates. PW2 fixed, resolution you have not
Only
appeared.
when my husband is appeared, they have not appeared, they are again appear, they have also tried to drag.
To undertake to appear, even if there is a resolution, I will immediately direct the
I-
trial court to
I will not, my lord, appear before the court below, my lord. I will not.
ask your counterpart to appear. Even if there is a resolution.
Petitioner will
You
support.
take a resolution, now you come up under 227. Both things cannot go side by side. You have to accept one, you have to forego the other. Both things cannot be done. This application under Article 227 of the Constitution of India is at the instance of the wife and is praying for a direction upon the learned additional district judge first track court number 2 at Barakpur to dispose of matrimonial suit number 1584 of 2020 expeditious. First of the learned advocate, Mr. Mondol, learned advocate, appearing for the petitioner submits that the matrimonial suit is being adjourned from time to time on the prayer of the opposite party. First up, paragraph. It appears that the in view of the order sought and proposed to be passed, there is no necessity to direct issuance of any notice upon the opposite parties. So, however, the learned advocate on record of the petition shall be obliged to forward a copy of this application along with this order upon the opposite party, as well as upon the learned advocate representing the opposite party before the learned trial judge. First up. Record reveals that the PW1 was cross-examined on 7th of August 2023 and discharged on that date. And 21st of September 2023 was fixed for examination of PW2. First up, thereafter, on 6th of December 2023, 24th of April 2024, 18th of June 2024, and on 10th of March 2025, the parties did not participate in the hearing on account of resolution adopted by the local bar association. First up, for such reason, the learned judge of the trial court had no alternative but to fix repeated dates for hearing for examination of PW2. First up, paragraph CO number such and such stands disposed of with the hope and trust that the matrimonial suit number 1582 of 2020 shall be disposed of in accordance with law without granting any unnecessary adjournments to either of the parties. Yes, next.
My lord, in this matter, my lord, there was a caveat. I am for the petitioner, my lord. I have served just now.
Just now,
It was, my lord, bona fide omission of my part of my learned clerk, my lord. So, my lord, kindly keep it any way, my lord, for them to go through the bit. It is a application for setting aside an order under 711.
What is the ground under 711?
My lord, limitation, barred by limitation. Barred by limitation.
Barred by limitation. What is the suit for?
My lord, suit is for a specific performance. The contract was admittedly 12 years back.
And what does the Limitation Act say? The starting point of limitation is from which date?
My lord, it has been in the plaint, it has been pleaded that all along I have been refusing. All along I have been refusing to contract, my lord. Rightly, wrongly, there was contract. That is a matter of trial, my lord. I'm not going to that matter. Only the contention of the plaint I'm saying, my lord. It is that this is he said there was an oral contract. There is no contract even that. An oral contract which was done prior to 2015. And that too, my lord, There is no contention in the paragraph that I have refused when. Lastly, he said that he refused on 23.
All right, Ashwin.
My lord, kindly keep it any day, my lord. I'll go on merits, my lord.
The learned advocate appearing for the petitioner submits that the caveator has been, that the learned advocate for the caveator, no, that a copy of the civil revision application has been served upon the learned advocate for the caveator only today. Full stop. Paragraph, the opposite party is represented by the learned advocate. First up, he prays for some time to go through the civil revision application. First up, list this matter under the heading motion after a week. Yes, next.
My lord, lordship may keep it on Tuesday, my lord. Otherwise, it will go into monthly list.
It will appear after a week. After a week, I have said. Yes.
So I'm appearing with the opposite party. Mr. Shonak Bhattacharya is appearing in this matter for the opposite party caveator.
Since I am not inclined to take up this matter on personal ground, this matter stands released from the list of this bench. Let the papers be placed before the Honorable Chief Justice for necessary orders. Yes, next.
My lord, the affidavit of service may be kept with the record.
All right, you file your every service. Every service filing code today is taken on record for them.
You can show before the trial court that they appeared. They appeared and we have served because the 8th of August is
All
the
right.
date, please.
Just file your every service. Yes, yes. Who is appearing?
My lord, defendant petitioner before your lordships. My lord,
Yes.
impugned order, my lord. One application, order 6 rule 70 preferred by the opposite party plaintiff has been allowed, and the another part is, my lord, order 39 rule 4. That is, my lord, applicable order. That application also, my lord, challenged in it. But I'm not pressing that, my lord. Only order 6 rule 17 application allowed by the learned trial judge has been allowed, challenged in the present application, because, my lord, they attempted to changing the, my lord, the cause of action. This is the original, the title deed, my lord, the
Show me the plane. Where is the plane?
yes, my lord. The plane, my lord, starts with page
23.
23. And the relevant part, my lord, paragraph 2 appears at 24. My lord, I'm placing the paragraph 2. That is, my lord, the origin of title. The Arman Bibi alias Arman Nesa Bibi, wife of Dosa Mondal, and Movarak Guldar, son of Movarak Guldar Sajna, were the lawful owner and possessor of the 5 decimals of land in Surdak. That while said Arman Bibi alias Anand Shiva was owing and possessing her share in Surdak, transferred the same in favor of said Movarak Guldar by virtue of registered deed of 1170 for the year 1936. That is the title deed, wherefrom the title has been accrued. This is the plaint case of the plaintiff. That title deed has been sought for deletion from the by preferring the amendment application, and that application has been allowed. So, my lord, the Movarak goal that is a predecessor interest of the plaintiff. Therefrom, the title has been transferred, and thereafter the plaintiff, the Akbar Shahaji, that is the 4th line of the last paragraph, obtain the title.
Where is the application for amendment?
My lord. My lord, page 54. That is the, my lord, proposed amendment portion. Lord. Now, kindly see the paragraph A and B. B is the, my lord, relevant. So there is no, my lord, title document. Even at the time of, my lord, the seeking the identity injunction, my lord, they have failed to produce the title document, that document, because this is my document, and I have disclosed by submitting my defense, my lord, in the written statement. Thereafter, they preferred this amendment application after long period of time. That is after 1 year. And after that, my lord, the paragraph would be, I can placing, if lordship permits me, that Arman Nisha Bibi, alias Arman Nisha Bibi, wife of Dosa Mano, that is paragraph 4. Lawful owner and the possessor of 12 decimals of land by virtue of registered deed. Number such and such, that is, I disclosed in my written statements, that while said Arman Nisa Bibi, alias Arman Nisa Bibi, was owing and possessing her share in suit that transferred 414 decimal of land out of 12 decimal of land under CS Khotian number 570 and CS Khotian number 372 in favor of Mobarak Goldar by virtue of registered deed only. They have not disclosed their title deed, description of the title deed. That is my primary objection. I taken out in my written statements. Will not kindly come to page 60, my written statement, paragraph 3. I specifically paragraph 3. No. According to me, this is absolutely not malified in nature. An attempt to change the cause of action, Lord, because cause of action arises from the original title deed, where from the title of the plaintiff accrued and developed.
Where the
that
title of the
deed-
plaintiff accrued by virtue of which deed?
That deed they preferred 11/70/1936 because these deed
Yes. So in the originally they said that they were the original owners. They did not mention the deed. Now they are seeking to mention the deed. How the cause of action will be changed?
they have not mentioned the description of the deed in the amendment.
Has been said by virtue of registered deed number they have given.
No,
Of
only registered deed, Lord. Kindly.
number 170/1936.
170/1936.
That is the deed number.
It is my deed. It is my predecessor deed.
Yes, that is the deed of Arman Ali.
Arman Nisa Bibi.
Yes. So they are seeking in. They have said that the Arman Ali. Yes, and Mubarak Goldar was the lawful owner of such and such Suddag.
My lord.
So by virtue of the deed, that
By virtue of not the deed, because I disclosed that deed. It is my deed, and thereafter the preferring this.
you have
amendment,
disclosed which deed?
His deed.
Yes.
170/1936.
So according to you also Arman Bibi was the owner by virtue of this deed.
Yes.
They are also saying that. Where is the dispute?
They also said that.
Yes.
But they have not disclosed their deed. Only
That is a different thing altogether. Ashun, this application under Article 220.
The leave of this, my lord. I am in this matter, but I was stuck in another court. But this order impugn has the two parts. One is order 6 rule 17, another is 39 rule 4 of the civil procedure. Lord, for latter part, I have to prefer an appeal. My client has been advised. If them, Lord, the order first part is, Lord, set aside, first part is approved by your lordship, then, Lord, I will lose my appeal.
I will protect your interest with you.
Lord, kindly consider. Lord,
I will protect that. For that cannot be a ground for.
Kindly one more thing, Lord. Kindly allow me to file the appeal, and I shall.
I will protect your.
I will appeal and.
I will protect your interest. I will say yes, Ashun. This application under Article 227 of the Constitution of India is at the instance of the defendants and is directed against an order dated 13th of March 2025 passed by the learned civil judge, Junior Division, First Court at Barasat, in title suit number 681 of 2022, paragraph. By the order impugned, the application under Order 6 Rule 17 of the Code of Civil Procedure filed by the plaintiff opposite party herein stood allowed. First up, by the self-same order, the application under Order 39 Rule 4 of the Code of Civil Procedure filed by the defendant/petitioner herein also stood rejected. First up, paragraph. The learned advocate appearing for the petitioner submits that the petitioner has challenged only the portion of the impugned order by virtue of which the application under Order 6 Rule 17 of the Code of Civil Procedure filed by the plaintiff opposite party herein stood allowed. First up, he further submits that since the order rejecting the application under Order 39 Rule 4 of the Code of Civil Procedure is an appellable order, and the petitioner is contemplating to challenge the portion of the order rejecting the application under Order 39 Rule 4 rejecting the application under Order 39 Rule 4 of the Code of Civil Procedure by filing an appeal before the appropriate forum. Such submission of the learned advocate for the petitioner is placed on record. Now this court shall consider the impugned order insofar as it relates to rejects to allowing an application under Order 6 Rule 17 of the Code of Civil Procedure. First of paragraph, the learned advocate appearing for the petitioner submits that the petitioner, that the plaintiff opposite party herein sought to change the cause of action of the instant suit by way of the proposed amendment. First up, he further submits that the petitioner, that the plaintiff opposite party herein has not disclosed the title deeds by virtue of which they have acquired title in respect of the suit property. First, he further submits that the deed which the petitioner sought to incorporate by way of amendment has been disclosed by the defendant petitioner herein in the written statement. First up, paragraph. After going through the plain, this court finds that in paragraph 2 thereof it has been stated that Arman Ali alias Arman Nessa Bibi and
it is Arman Bibi.
Arman Bibi alias Arman Nessa Bibi, that has been stated in paragraph 2. Arman Nessa Bibi and Mubarak Goldar were the lawful owners and possessor of the suit dag. First up, as to how they became the owner of the suit dags were not stated in the original plain. First up, by the proposed amendment, the petitioner sought to incorporate the fact that the aforesaid persons became the owners by virtue of the registered deed number 1170/1936. First up, thus it first up, paragraph. With regard to the submission of the learned advocate for the petitioner that the opposite party has not disclosed the title deed by virtue of which they have acquired title, it appears from paragraph 2 of the plain that it has been stated specifically that Alam Sahaji, while owning and possessing the suit property, died leaving behind his only son Akbar Sahaji as his only legal heir and successor. So while Akbar Sahaji was owning and possessing the suit property, he died leaving behind him surviving the plaintiffs as his only legal heirs and successors. First up, thus it appears that the plaintiffs have claimed title in respect of the suit property by virtue of inheritance. Paragraph. After going through the proposed amendment, this court finds that the same are necessary for the purpose of deciding the real controversies between the parties. First up, it cannot be said that by the way of proposed amendment, the plaintiff opposite party herein has sought to change the cause of action for filing the suit. First up, the proposed amendment, the nature and character of the suit also cannot be said to have been changed by way of the proposed amendment. First of all, for such reason, this court is not inclined to interfere with the portion of the order impugned by virtue of which the application under Order 6 Rule 17 of the Code of Civil Procedure stood allowed. First up, it is however made clear that this court has not entered into the portion of the order impugned by virtue of which the application under Order 39 Rule 4 of the Code of Civil Procedure was rejected, and the petitioner is left free to take appropriate steps in that regard before the appropriate forum. First up, for the above reasons, CO number such and such stands dismissed. There shall be, however, no order as to cause urgent photostat certified. Thank you.
Shall not be swayed by the observation made by you.
What observation? This is with regard to the amendment. Yes. Certified copy cannot be given back because this is part we have to obtain another certified copy. Yes, next.
Lord, item number 26, I appear for the petitioner. I'm
Yes.
being led by Mr. Uday Shankar Chattopadhyay in this matter.
Please proceed.
Yes, my
proceed.
lord, I have instructions to not press this matter because this has become infructuous, my lord.
The learned advocate appealing for the petitioner submits that due to passage of time, the instant application under Article 227 of the Constitution of India has become infructuous. First of all, in the light of the submissions made by the learned advocate for the petitioner, CO number such and such stands dismissed as infructuous. Yes, next.
Yes, my lord, here I appear for the petitioner. I'm being led by Mr. Kaushik Dey in this matter. My lord, I have challenged two orders, my lord. The first order is 19/11/2024.
Yes.
Thereby, what has happened? The learned trial court has held that the amended written statement of the substituted defendants is bad in law and did not consider it, and the suit has been set ex parte against the said defendants.
Yes, who are you?
I'm the defendant number one in the suit, my lord. What has happened?
Defendant number one.
Defendant number one. Yes. My lord, initially the defendant number one filed a written statement in the year 2001. Thereafter,
Yes.
defendant number 2 and 4 filed a separate written statement in the year 2005. Now, the defendant number 2 died and he was substituted by the defendant numbers 2A to 2D, wide order dated 22nd January 2013. Thereafter, the defendant numbers, substituted defendants, adopted the written statement of their predecessor. On 16th August 2016, a fresh wakalatnama.
How are you prejudiced? Your written statement will be considered.
My
You have not filed. Yes. You are the defendant number one.
I am the defendant number
So
one.
how are you aggrieved by this order? You are not the affected party. Whose cause you are trying to ventilate? Whose cause you are trying to ventilate?
He had actually filed a joint joint wakalatnama, my lord.
Maybe, but your written statement is protected.
My written statement is
So
protected.
you are not
My
affected.
lord, what has happened? The amended.
The other defendants have not come up. Your written statement is protected, and you have also not been set ex parte. Let the others come.
I have not.
By the order impugned. Now, this application under Article 227 of the Constitution of India is at the instance of the first defendant and is directed against an order being number 222 dated 19th of November 2024 and the order dated 226 dated 29th of April 2025, both passed by the learned judge, fifth being Presidency Small Causes Court at Calcutta in ejectment suit number 2851 of 2000. First up, by the order dated 19th of November 2024, the learned trial judge directed that the suit to be proceeded ex parte against the defendant numbers 2 within bracket A to 2 within bracket D, and the plaintiffs were given liberty to adduce evidence in view of the written statement of the defendant number 4 filed on 21/11/2005, and the defendant number 4 was also given liberty to adduce evidence on his behalf. First up, thereafter, what happened? 151 filed
For recall of the
by the defendant number 4. No, who
No.
filed that application?
This has been filed by the defendants.
Defendant numbers 2A to 2D.
No, from the recall application, it has been filed by the defendants, my lord. All the defendants.
And to allow the defendant numbers 2A to 2D to contest the suit, by the order dated 29th of April 2025, the application under section 151 of the Code of Civil Procedure, praying for allowing the defendant numbers 2A to 2D to contest the instance suit stood rejected. First up, after going through the impugned order, this court finds that the the petitioner, who is the defendant number 1 in the said suit, cannot be said to be prejudiced by the impugned order. First up, no right of the defendant number 2 appears to have been affected by the impugned orders. First up, for such reason, this court is not inclined to entertain the civil revision application at the instance of the defendant number 1. With the above observations, your number successor stands disposed of. There shall be
Grateful, my lord.
Yes, next.
My lord, for the petitioner, my lord. The petitioner is a decree holder, my lord, for rupees 10 lakhs, which is pending at the 3rd Civil Judge Senior Division at Barasat, my lord. The respondent number 1 will retire from service in September 2026, my lord. The learned court, the trial court, has attached 1/3 of salary, that which comes to rupees approximately 22,000, my lord, which will not cover the decretal amount, including interest. My lord, normally the pensionary benefit cannot be attached, but according to the Supreme Court, there is an exception. When the pensionary benefit reach to the hands of the retired employees, that can be attached, my lord. In the same order, the Supreme Court, Honorable Supreme Court, directed the subordinate court will go into the merit and find out how the execution will be conducted. My lord, I am giving the Supreme Court order, my lord.
Which order you are challenging?
I am challenging the attachment order, my lord.
Which order? Order
The page number 17.
Order?
Page number 17.
17.
17. 1/3 salary was attached, my lord.
22nd of May 2025.
Yes, my lord.
You are for the decree holder?
Yes, my lord.
Yes. So how are you affected? Order has been passed in your favor.
Yes, my lord. But the respondent number 1 will retire from service in September 2026, my lord. And
Yes.
22,000 per month attachment will not cover the decretal amount, rupees 10 lakhs, including interest since 2016, my lord.
What is the decretal amount?
Decretal 10 lakhs. 10 lakhs, my
Yes,
lord.
what is
Page
the
number
judgment
28.
you are citing?
Yes, my lord. My lord, kindly come to para 12 and para 15, my lord. Para 12, my lord, we may state without fear of contradictions that provident fund amount, pension, and other compulsory deposit covered by the provisions we have referred to retain their character until they reach in the hands of the employees, my lord. So that cannot be attached, but after it reach to the hands of the employees, that can be attached. And
yes.
Yes, my lord. Now kindly come to para number 15, my lord. Para number 15. We direct the court of the subordinate judge to go into the merit of the objection raised by the Union of India as to whether the entire amount or any portion thereof held by it on behalf of the Rajya Sabha Secretariat staff So far, the judgment debtor in the case is concerned represents provident fund, compulsory deposit, pensionary benefit excluded for attachability in execution civil decree under the provision already awarded to. If it is feasible to effect service of the notice to the judgment debtor, well and good. But if it is not, the court cannot absolve the duty to investigate into the merits of the claim and character of the amount, so long the Union of India is ready to make the good its contentions.
So according to you, if the amounts after receiving that can be attached.
Yes, my lord.
So where is your prayer? Where is your application for attachment? Where is your application for attachment?
Direction upon the trial court to issue notice upon the drawing and disbursement officer of the office of
Page, where is the application?
page number 13, my lord, prayer part.
Page number
13, prayer part.
13.
Yes.
No, that is the spare in the civil division application. Where is your application filed before the learned
Learned trial court, my lord. Yes.
Yes, for attachment. Where is that?
Yes. Page number 18, my lord. Prayer part is page number 19.
Yes, so after it reaches, it can be attached.
Yes.
But how can that be attached by the employer? That cannot be done. This judgment also says that that cannot be done.
That cannot be done, but
So,
subordinate court.
Will be difficulty, sir, if other side comes and challenges.
Yes, my lord.
This will be set aside.
Yes, my lord.
Then you decide what.
But unless that can be done, my lord, they will escape from the hands of the law, my lord.
But that's a different thing altogether. This is an order attaching the pension, whether it can be attached. I think section 60 protects that. Cannot be done.
After
it reaches, do whatever you like. But it's done prior to that, it has been attached. So from his salary, it will be deducted. Public Provident Fund, KA, cannot be attached. Only 1/3 of the salary in execution of any decree for maintenance. That has been done rightly.
Yes, that was rightly done, my lord.
So,
So direction upon the lower court to goes into the merit of the case according to the Supreme Court judgment, my lord. That is my prayer.
Ashwin. The learned advocate appearing for the petitioner places reliance upon a decision of the Honorable Supreme Court in the case of Union of India versus Jyoti Cheat Fund and Finance and others, reported at 1976, 3 SCC 607, in support of his contention that attachment is possible and lawful after the amounts are received by the employee. So the petitioner is directed to serve a copy of this application by registered speed post with acknowledgement due and file an affidavit of service on the next date. List this matter under the heading contested application after 12 weeks. Yes, next.
The order passed by the district legal services authority is under challenge.
What is the order?
Yes. The dispute between the parties regarding the settlement of a big water body, where the lease rate is rupees.
ULSA is the authority.
Yes. 227 is maintainable, I will come to that.
No, no, DLSA is the authority
Yes.
for deciding that.
That whether this amount can be all can be at all entertained, but more than 10 lakhs is also subject matter of section 22 subsection 5, my lord. Now one can consider how it has been dealt with. My case is that no compromise was effected, and if a lordship may kindly consider the order
Under what
passed.
provision this has been filed? Which act? Which is the provision?
The legal service, district legal service. No.
With the provisions which
Yes. Legal service
on
also
payment
gives
of rent or premium payable to the landowners. What is the dispute?
Yes. Settlement of a water body.
Who has settled?
The opposite party is herein.
Who is the opposite? Who is the authority?
No, not the authority.
Private party.
Yes, private.
There was a lease.
Lease. Settlement or lease is that.
Yes.
I have to pay rupees 53
So you are the
per year.
lessee. You are the lessee.
I'm the lessee.
Yes. What happened?
I have to pay rupees 53 lakhs per year as a lease rent. I have paid.
You are not paying.
I have paid, and rest of the amount they said their lease of 9 years. Though unregistered lease deed ballot, that is subject matter of challenge. I have to pay money. Just before completion of 1 year, they started, you have to pay the entire money. I have already read the fees and I have to catch it out. I cannot pay from my pocket. I have produced the documents where from it will appear more than 1 crore 40 lakhs I have paid for the purpose of doing the physiculture. They stopped my activities.
The recorded water body.
Yes.
Or
No.
agricultural land.
No, not that.
From somewhere else.
Not the cutting down the embankment and flows the water, not that one. That is not the case. Now, my lord, what happened? I filed an application before the authority. DLSA. Now, my lord, can turn to the order.
So with the authority of the DLSA to decide this.
Yes, that apart from that, my lord, why I have
applied, Mr. Rai.
That is why there is no compromise. Then how this order was passed?
Show me the authority of the DLSA first to decide this type of dispute.
Your lordship may kindly consider the jurisdiction of 22 subsection 22C. Permanent local the district.
22C.
Yes, your lordship find.
Any party to a dispute may, before the dispute is brought before any court, make an application to the permanent Lok Adalat.
This is a district local adalat, but district legal service authority, but under the state.
Settlement of dispute, provided that the shall not have jurisdiction in respect of any matter relating to an offence. Permanent Lok Adalat shall not have jurisdiction in the matter where the value of the property in dispute exceeds. How the value is to be calculated?
So the dispute, the lease rate is 53 lakhs. That is why I present.
No, yearly or the total?
Yearly.
Yearly is 53 lakhs.
Yes.
But you are saying that there was no agreement. There was no consent or there was no agreement.
Yes, that is why. Precisely.
How can that be?
It can be passed, page 96.
How can that be decided in 227,
Yes,
Mr. Rai?
that was held, my lord, precisely. This is the 227 is maintainable if your lordship.
Even if maintainable, how can the revisional court decide as to whether there was any agreement between the parties? That's a factual thing which can be done.
That is why, my lord, can you turn to page 96, my lord, once.
96 of
this revisional application.
Yes.
Why I said that order starts from.
Yes.
At the left hand side, my lord will find the signatures appearing.
Yes.
Navakumar Maiti.
The signature is there.
Yes.
Yes.
Next page onwards, your lord should find. And last page.
Yes. So it's an agreement. Settlement arrived at.
It was not that. That is why first page, my lord, second page, all spouses signatures appearing, not mine.
No, who are you?
Navakumar Maiti. The first page, Ramakanto Maiti. Novakanto.
You are Novakanto.
First page I have there. It is. I categorically mentioned that yes, the signature was after that I was present on that date. Subsequently, no agreement was arrived, and it was this dispute was resolved. Who are the persons present? Only the opposite parties.
That is why, my lord, page 99. Page 99, I'm conscious about, my lord, how can the revision court can go into this factual aspect. 99. I've
Yes.
categorically said that this application, because there is no format to that extent, that I have never agreed to that about how this order can be passed. This was received.
Mr. Rai, that authority can decide.
That is
But
why.
how can the revisional court decide? Mr. Rai, what happened before the DLSA, I do not know. So it's very difficult if you apply that principle that the records of the court is
That is
sacrosanct.
why I have to apply before the same authority.
Yes.
Page 99.
Yes, you have done.
Yes.
And what did the authority say? It's pending.
It's still pending.
So I can direct that authority to consider. What more? How can I decide, Mr. Rai, here?
Two things. One is more than 10 lakhs, whether the jurisdiction is.
Everything. Mr. Rai, may not be that both of you have agreed to that.
Then also whether the council can confer jurisdiction.
Here, yes. Here, yes. Unless you give consent, that authority does not have.
Yes. So there must be something on records to show.
That is the authority is the best person to decide on that. How can the revisional court decide on that? Whether you orally submitted, not submitted, it's only that authority who can say. How can I from here say whether you consented to that or not?
So far, what is followed from lordship is the factual aspects. But so far,
how can this
this squarely came up for consideration for the Honorable Apex Court also. What will be the remedy then? Lies. Today, I have privately shown to your lordship that yes, there is no signature on the regarding the disposition part, but the clauses are mentioned. Second page onwards. My categorical submission was
file a suit also.
That was dismissed on the ground on the basis of this order. Injunction refused, rejected.
Where?
Because the court below.
No, you are, after that you have filed a suit.
Yes.
Where is that? You have not shown me that.
Because page 93.
So you are challenging this order of the trial court?
No. I have filed a several suit for declaration injunction. Yes. In such, I have not aware of this order. It has not been communicated to me. They filed an objection and they have annexed this order. On the basis of which the trial court said.
Now, Mr. Rai, what was this also? In that, this order of the DLSA was not challenged on the ground of fraud or whatever it might be. So that was not challenged. On that ground, the learned trial judge has refused. So, but
that order.
So you ought to have challenged that order by a suit, or you can amend your plain, whatever it might be.
So, I cannot challenge this order, DLS's order, which is staring on my face. This is an agreement between me and the defendants.
Mr. Rai, if you say that consent was not, it's a fraudulent one.
Then fraud.
Suit lies. Because, Mr. Rai, if that is not permissible, if 227 also court cannot decide that. How can the court decide that if you say...
That is why, my lord, whether privacy have to consider whether those ingredients are mentioned in the statute is there or not. My lord has to consider that. Agreement.
Supreme Court decision you are saying.
2008 volume 2. SCC page 660. Paragraph 20. Paragraph 5.
Paragraph 5 থেকে 8
Paragraph 8 onwards, my lord, your lordship find. With guidance and assistance from the Lok Adalat.
No, Mr. Rai, paragraph 10. This was a case where the Honorable Supreme Court says it does not have any adjudicatory role. It's only a conciliation. In that case, what happened, it was an adjudication made. On that ground, it said 227 can interfere. But here is a case, here the case on hand is not that. Here, both the parties have arrived at a settlement. Now, that's the recording. So there is no adjudication made. There is no adjudication made. So on the basis of settlement or consent, whatever it might be, the Lok Adalat passed an award. Now you are saying, you are coming before the 227 court and saying, no, 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 I did not give consent. So that's a question of fact. How can the High Court decide on that? This decision is not on that. Paragraph 12 of this decision.
It is true that where an award is made by the Lok Adalat in terms of a settlement arrived between the parties, which is duly signed by the parties and annexed to the award of the Lok Adalat.
Yes, yes, but Mr.
Precisely.
Yes, yes, but award. In this case, what was done? Adjudication made.
There is no settlement. That is why the award must be coupled with the settlement.
No, no, no.
Yes,
not in your case. I am talking about the reported decision.
It is true, Malat Kali, paragraph 12, Malat. It is true that where an award is made by Lok Adalat in terms of a settlement arrived at between the parties, which duly signed by the parties and annexed to the award of the Lok Adalat. So, award must be preceded by a settlement agreed between the parties, which must be formed of a part of the, as if a commission report. This is the final degree proceedings.
রে বাবা
Yes, Mr. Rai, paragraph 12, it says, if any party wants to challenge such an award based on settlement,
yes,
it can be done only
limited
by, yes.
That is why.
Based on settlement.
Here is.
So now, on limited grounds. So, here is not a case, or this does not mean to say, when you are denying that there was a settlement, that can be entertained in 227. It's the other way around. There was a settlement, an award was on the basis of that settlement. Now you want to challenge that because appeal is not maintainable since it's a 227, 226 you can maintain, but on very limited grounds. So settlement is not in dispute, but you are challenging something here and there in the settlement. But here you are questioning the settlement. That's a disputed question of fact, Mr. Rai.
Kindly consider that, what is the award? This is the award which has been mentioned, page 96.
Page 96, award is the settlement.
It should be coupled with the settlement. That is precisely what I am inviting your lordship. What is the award? I put this question to myself. In terms of the paragraph 12. Award is simply not the production of any settlement between the parties orderly. It should be written, signed by the parties and be part of this.
Award is page 96.
Yes.
Award is up to this.
Yes.
From the petitioner such and such, next heard both sides, details deliberation, the dispute cropped up by such and such, detailed full discussion held face to face, and upon such the following terms. Yes. This is the award, Mr. Rai, as in a compromise petition. You file a compromise petition that is made a part of the decree.
What is that part? I put this.
This is this.
No, subject to question. Where is the signature?
Between the parties, the following terms have been developed and the parties agreed to that.
No signature of mine. There is no signature of mine.
What is your allegation with regard to this? Show me.
Yes, well, can I turn to my the letter itself, my lord, page 99.
Yes. Show me that relevant part.
Yes,
What is
last
your
1, 2, 3, 4, 5, 6 lines from the bottom
of that page?
of that page, page 99.
Yes, পরবর্তীকালে
উক্ত ধার্য দিলে
Yes,
my lord,
yes.
শুনানির আগে উভয় পক্ষে হাজিরা হিসেবে একটি সাদা কাগজে সই সম্পাদন করিতে বলা হয়। আমি উক্ত সম্পাদন করি। পরবর্তীকালে উক্ত কেসটি শুনানির সময় বিভিন্ন তাদের প্রভাব খাইতে থাকে এবং আমাকে তাদের কথা মতো দাবি দেওয়া মানিয়ে নিতে সম্মতি প্রদান করিতে বলেন। অথচ আমি ওনাদের দাবি না মানিয়া শুনানি স্থল হইতে কোনো রকমে চলিয়া আসি। উল্লেখ থাকে পরবর্তীকালে আমি তমলুক কোর্টে একটি দেওয়ানি মামলা দায়ের করি, যার দেওয়ানি মোকদ্দমা নম্বর সাজ উক্ত দেওয়ানি
So
মোকদ্দমা
your case was that on that blank paper you have signed.
yes, why that will also appear why it was there. Kindly consider the first page.
Yes, yes. So according to you, in one page, blank paper you have signed that was subsequently converted to an order. And the second page contains the terms and conditions. It does not contain your
And the last also, the last also regard to my signature. Yes. এত কষ্ট করে এতক্ষণ লড়াই করে এত
the order dated 18th of April 2024 passed by the passed by the না করে এটা ঘুরিয়ে লিখুন তো। The order of the Secretary District Legal Service Authority Purbo Medinipur dated April 1 2020 dated April 18 2024 in the case of Nobokanto Maiti versus Tarendranath Jana and others under reference number 01/April/2024 is under challenge in this civil revision application. So Mr. Rao, under advocate appearing for the petitioner, submits that the signature of the petitioner was taken on a blank paper and the same was subsequently converted into an order dated 18th of April 2024 containing the terms and conditions of settlement. First up, Mr. Rao, honored advocate, submits that the petitioner did not agree to the terms and conditions as incorporated in the order dated 18th of April 2024. First up, Mr. Rao.
The observation that how the award should be there because it is paragraph 12 of the
Yes, yes. Mr. Rao, honored advocate appearing for the petitioner, places reliance upon a decision of the Honorable Supreme Court in the case of State of Punjab and another versus Jalaur Singh and others, reported at 2008-2 SCC 660, and places strong reliance upon paragraph 12 thereof, wherein it has been held that if any party wants to challenge an award of the Lok Adalat based on settlement, it can be done only by filing a petition under Article 226 and/or 227 of the Constitution. First up, petitioner is directed to serve a copy of this application by registered speed post with acknowledgement due and file an affidavit of service on the next date.
page 16 last portion, my lord. Page 16 last portion.
What?
Stay.
Page
16.
Ad interim stay of that order.
Yes, operation of the alleged order. Alleged award, my lord. Cannot be ordered, my lord. Alleged award.
After perusing the order dated 18th of April 2024, this court prima facie finds that the signature of the petitioner, namely
Navakumar Maiti.
Kumar or Novokanto?
Navakanto Maiti. Navakanto, my lord.
The petitioner, namely Novokanto Maiti, is appearing only in the first page and not the
Terms of settlement.
subsequent pages where the terms of settlement has been recorded. First up, in view thereof, the petitioner has made out a strong prima facie case for grant of an interim order. First up paragraph, there shall be an order of stay of operation of the order dated 18th of April 2024. Order of the Secretary, District Legal Service Authority, Purbo Medinipur, dated 18th of April 2024 in case reference numbers 01 of 2024 till the end of the month of November 2025 or until further orders, whichever is earlier. First up, the point of maintainability of the civil division application, because in their absence, because they have to be,
It is a law laid down by that is.
they may say something other that is
Yes,
why, because
suddenly.
the point.
Let them take. If they are taking that point, then my lord, it should be decided. Irrespective of fact whether my lord is admitting the application or not.
Yes, call the next matter. Yes.
Lordship, I am for the petitioner.
Yes.
Lordship, being aggrieved by the order dated 2/7/2020.
Mr. Rai, appear contested application.
August.
Monthly list of August. August to September. September. Yes.
Lordship, being aggrieved with the order dated 2/7/24, passed by the learned first ADJ Alipur without considering the facts that I have to deduct near about 17,000 from my salary as a home loan, and also the submission stated by the private respondent number 2 wife without following the guidelines as stated in the ruling in Rajnish and Neha. I have preferred this year to set aside or alteration the quantum of maintenance passed in the implement order therein.
What is your income?
Lordship, net income 56,600.
Not net income.
Gross income.
Gross income less statutory deduction. What it comes? 63.
Gross income 63,362.
Yes. Yes. And what is the yardstick set by in Rajnish versus Neha? What is the ratio which is to be applied?
That should be 1/4, sir. But after deducting the home loan EMI.
Show me. Home loan EMI has to be deducted. Show me.
Lordship, kindly consider.
Show me the judgment of Rajnish versus Neha.
No, not Rajnish Neha. It is mentioned in Bhushan Kumar Min versus Manashi Min at Harpreet Kaur.
Sir, if you take a home loan and pay installments of your entire salary, you need not pay anything.
Not I am paying entire salary. It's only
15,000 you can pay for home loan installment. Pay 15,000 to the wife.
But Lordship, consider that the Rajnish has the guidelines that you have to come before the court with petitioner wife, actual financial status, and
how is the affidavit of assets and liabilities filed by you? Let me see.
Yes.
Yes. Show show me your affidavit of assets and liabilities. Have you annexed that?
Yes, Lordship, page
So-
16.
1/6.
Yes.
Yes. Where is your salary certificate? Yes, show me the decision which says that the installment for house building loan is to be deducted. Show me.
Yes, Lordship. Lordship, kindly consider page number 6, paragraph number 12 of the petition.
Not the petition. You said you are relying upon a decision which says that the installment of home loan is to be deducted.
Yeah, is
Not that it is to be, that percentage is to be calculated.
Yeah, it is mentioned over there in paragraph
Show me
number
the
12.
decision, not paragraph will not do. Show me the decision.
Lordship, I prefer liberty to submit on next date. I will collect
After
it.
some argument, the learned advocate appearing for the petitioner prays for an accommodation. In view thereof, CO number such and such stands adjourned. So, yes, call the next matter.
Sure, please.
For declaration and permanent plaintiff in a suit for declaration and permanent injunction is the petitioner before your lordship, my lord. The revisional application is directed against rejection of my 2 application, my lord. One application I have filed for cultivating and harvesting the suit property, and another application for putting up the entire record for adjudication of the injunction application, my lord. That 2 type application was rejected. Parallelly, the application of the opposite party praying for cooperation of the police authority to cultivate the land.
The order of injunction.
Original order.
Show me the order of injunction.
Kindly page 23, my lord. The original application for injunction. The operative part, 24 page. Original order.
Is that interim or temporary?
Temporary, my lord. My lord, kindly see the middle portion of the paragraph. Having produced the registered deed of this
Page 24.
page 24, my lord.
Yes.
The middle
Please give me a minute. Please give me.
Yes. And at this juncture, when the opposite party tried to disturb my possession, my lord, I am kindly come to very next page, page 26, my lord.
Yes.
I have filed an application under section 151 for the police help, my lord. That was also
Implementation.
implementation of
What
the
happened
order.
to that?
That was allowed, and trial court directed the police authority to cooperate when I am harvesting and cultivating the property. At this juncture, my lord, when I am
Have applied for that.
no. When I am suffering from heart problem, my lord, I am admitted in the hospital. The opposite party suddenly entered the suit property and started to cultivate. At this juncture, my lord, I have filed the application 1551 for allowing me when I will recover further operation, I have entering the
How
property.
can that be recovered when you have said you have been dispossessed? How
No, disposes, no.
they have cultivated,
Cul-
madam, they have cultivated.
Order of injunction was.
What is the application which has been disposed of by the impugned order? Show me that.
Page 34.
When did you file this application?
On 2nd August 2024.
Season is over. That was for that season.
No, this is rainy season, my lord.
That's
That is different. Rainy season, all that.
This application was disposed of by the impugned order. Rainy season is over of 2024. It's the 2025 no application has been filed.
Last year, my lord, 2024.
Last year, 2024.
It is true that I am in possession, my lord, after satisfying that all the record of rights in favor of me, the landlord trial court was pleased to pay.
But the difficulty is
Injunction order in favor of me, my lord.
you have filed this application in August. Your prayer was to give police help for harvesting for that season. That's over.
That's why, madam, my lord, it is not true that I am in
Give you
possession.
liberty to file a fresh application for this year. That will be considered.
My lord, kindly see the impugned order.
Yes.
That application has been rejected with cost, my lord. That is
Cost, that can be deleted. Cost can be deleted, but the subsequent
it is my property, my lord. I all along landlord trial that after satisfying.
I'm giving you liberty. It has become infrastructure now.
Happen, my lord, it will be taken up by the opposite party, my lord. When I am all along in the property, I have harvesting and cultivating the property. Enjoyed by the opposite party, my lord. This is
In
true.
August 2024, you have filed that application, madam. What is the season for harvesting?
Maybe
When the harvesting is done.
it is true that I have
The harvesting is done.
that is, my lord, this is a Bengali, this is illiterate person, my lord. Kindly consider, my lord.
You are saying
that is-
harvesting. What is the harvesting season?
That is June, July, my lord. That is true, my lord. This is rainy season, but kindly consider, my lord, the crops of the.
I can give you, it was for the year 2024.
My lord, let the opposite party come. They have written, they are all.
Giving you liberty.
But my lord, kindly consider, my lord, this is true.
Nothing can be done. The clock cannot be set back. We cannot go to 2024 rainy season. Your prayer was for that.
This is continuous problem, my lord. They are already disturbing my possession in spite of
I'm
obtaining the
directing
police
the best thing is that what is the stage of the suit?
stage, my lord.
What is the stage of the suit?
That I will take instruction, my
I
lord.
can direct the suit to be expedited. And I will also give you liberty to file an appropriate application for this year. This application under Article 227 of the Constitution of India is at the instance of
My lord,
the,
evidence is going on, my lord.
then I am expediting the suit. Kyolo, this application under Article 227 of the Constitution of India is at the instance of the plaintiff and is directed against an order being number 37 dated May 22, 2025, passed by the Learned Civil Judge, Junior Division, First Court, Gandhi District, Murshidabad, in title suit number 241 of 2022. Posted by the order impugned the application filed by the petitioner. What is the other application? 29th of
That
April?
is filed by the opposite party, the same prayer, my lord. To harvest and cultivating the suit property. They have also claiming that they have cultivated the land, my lord.
Oh, their prayer was allowed.
Their prayer is allowed, my lord. Kindly consider.
Court was satisfied that they have cultivated. What can be done? There is substance in the argument of the learned advocate for the petitioner. that the learned trial judge, while deciding an application under section 151 of the Code of Civil Procedure for implementation of an order of status quo, directing both the parties to maintain implementation of an order of status quo. Implementation of an order. Where is the order of status quo?
Page 24, my lord. Page 24.
No, praying for implementation of an order directing both the parties to maintain status quo with regard to nature, character and possession of the suit property could have granted police help could have directed the officer in charge of the concerned police station to take necessary steps so that the defendant can harvest and cut away the ripe paddies from the suit property. First, the petitioner is directed to serve a copy of this application by registered court with acknowledgement due and file an affidavit of service on the next date. First up, list this matter under the heading motion. Crops have been taken away. What purpose will be there?
Please stay of the operation of the order, my lord. Kindly then post it.
Infructuous. It will be an infructuous order. Motion August monthly list. এটাতে করে দিন it is however made clear that pendency of this application shall not preclude the learned trial judge from proceeding with the hearing of the suit.
Stay of the operation, my lord. Kindly.
Nothing will happen. It will become an infructuous order. It has been done. Yes,
Okay.
call the next matter. 32. All right. Come at 2 p.m. Yes.
But before your lordship rises, Lord, I was available in the morning, Lord. Extremely urgent matter at item number 300. কোথায় গেল? Lord, we've written the urgency.
Hand over the slip. I will consider.
332, Lord, if it comments to your lordship, kindly, Lord, this is it's been
Mr.
sent to the
Chatterjee, I am
arbitrator
looking to all the mentioning slips.
to take a lot
So
of.
provided you can satisfy the urgency, it will be listed.
Lord, takes up a lot
Because
of.
we will be finding every day in the supplementary as well as the monthly list, some matters are being fixed. But may be difficult till 24th, all dates are full.
Thereafter, Lord, I don't have a.
Till 24th, all dates are full.
24th of July, Lord. Thereafter, I don't have a.
So
The problem
hand over the slip. Please mention the urgency. In most of the slips,
they don't.
They are not. Only upgradation slip. Unless the urgency is mentioned, Mr. Chatterjee, is very difficult.
My problem is, Lord, that in my claim, an arbitrator, Lord, has been appointed.
To indicate that, you indicate that I am personally going through all the slips. That much I can assure you. constitutional ground. This matter stands released from the list of this bench. So let the papers be placed before the Honorable Chief Justice for necessary orders.
So I am the plaintiff suit for permanent injunction. Lordship, kindly come. Previously, I filed an application under Order 39, Rule 7, which was allowed and the Commissioner's report at page 29. Now, Lordship, Commissioner's report conducted by the learned advocate who is not a survey first advocate.
No, Order 26, Rule 9 has been rejected.
Initially, I filed an application under section Order 39, Rule 7.
Yes.
It was allowed.
Yes.
This report at page 29, the suit for injunction.
Yes. Now, what happened after that?
And also this Commissioner's report was conducted by the learned advocate who is not a survey first advocate. Now, Lordship, this Commissioner's report is not at par in terms of my Lordship, the points for which I have applied for Order 39 Rule 7.
Yes.
Subsequently, Lordship, Lordship, kindly come, the only sketch map is page 30.
No, show me the plaint. What is the
Lordship, the
suit
kindly plaintiff.
Who are you in the suit?
I'm the plaintiff suit for injunction.
Suit for injunction.
Yes. That starts from page 18.
Where are the points for local investigation?
Listen, points for local investigation at page, Lordship, the page 25. তপশিলভুক্ত জমি বর্ণনা কি রূপে অবস্থান আছে তাহার রিপোর্টে পুঙ্খানুপুঙ্খ রূপে বর্ণনা করিতে হইবে। ফার্স্ট পয়েন্ট। সেকেন্ড পয়েন্ট, দরখাস্তের ক তপশিলি পারিপার্শ্বিক অবস্থান দেখাইয়া একটি নকশা প্রকাশ করিতে হইবে। Kindly come their report. The Survey First Commissioner himself admitted that he has no knowledge of local conducting the local inspection.
Yes, what is the purpose of local investigation?
So first of all, local inspection has not been conducted.
No, forget about local inspection. What is the purpose for local investigation? Why it is necessary?
Why? Because kindly come my plane.
Yes.
Lordship, the map, page 23.
Yes, page 23.
Yes, this is the
23
map.
is not your plane.
Yes, part of my plane is a map.
Yes.
Now, Lordship, kindly come the Toposil Corp. Lordship, this Toposil Corp belongs to the plaintiff, and the plaintiff, this is the pathway how the plaintiff is enter with the full cat. Lordship, everything is the only way to enter into the plaintiff's the residential house.
Yes.
Now, this has been obstructed by the defendant, that is Sudhir.
Obstructed means encroached.
Encroached, Lordship.
So where is the map of encroachment? Show me. You have not made out any case of encroachment. You have only said permanent injunction that he should not disturb your possession. You have not made out any case of encroachment.
This is not a public road. This land belongs to me. I have space for my ingress and egress.
No difficulty for that. Local investigation is not necessary.
Now, let's say for that, kindly come the local inspection report.
I'm not on local inspection. I'm concerned whether local investigation can be done or not.
No obstruction, let's say kindly come by local investigation.
But maybe you have not amended your plaint. You have not amended your plaint. You have not till date made out any case of encroachment. Make out that case of encroachment. Otherwise, this is nothing but a.
Kindly come to 31. This
Yes.
is application for local investigation.
31.
Yes.
Yes.
Jela Birbhum Thana Lavpur.
No, you have placed that handwritten one. What was that handwritten one? You have placed the previous handwritten application. What is that?
That is the application for local inspection.
No. I want to see the local investigation. Yes.
This is the page 32.
I wanted to see the local investigation. You have taken me to that. I thought that it is the. Yes. How these points are relevant?
Lordship, kindly come my plane.
Yes. Show me from the plane that is necessary for the purpose of deciding.
So kindly come page 20, paragraph 5.
Yes. Yes, creating disturbances. For creating disturbances, this local investigation may not be necessary. Yes, Ashun. This application under Article 227 of the Constitution of India is at the instance of the plaintiff and is directed against an order dated 8th of April 2025, April 8, 2025.
Also, this local inspection report, which is already filed.
That is neither here nor there.
Yeah, I have not challenged. Lordship, let me challenge this local inspection report.
That you do in separate proceedings. April 8, 2025, passed by the Learned Civil Judge Junior Division, 2nd Court at Bolpur District, Birbhum, in title suit number 68 of 2018. By the order impugned, the application under Order 26, Rule 9 of the Code of Civil Procedure stood rejected. First up, the petitioner filed a suit for permanent injunction. Filed a suit for permanent injunction, restraining the opposite party from creating any disturbances in the peaceful possession of the petitioner in respect of the cost scheduled property. The cost scheduled property has been described in the schedule of the plaint. First up, paragraph. The petitioner filed an application for local investigation, praying for an appointment of a survey past advocate commissioner. First up, after going through the points for local investigation, this court finds that the petitioner has sought for relievement of the cost schedule and cost schedule, schedule property, and to prepare a sketch map thereof. First up, the petitioner has also sought for an opinion from the opinion of the survey past commissioner as to whether cost schedule property is a part and parcel of cost schedule property. First up, after going through the considering the scope of the suit, this court is of the considered view that the local inspection on the points sought for by the petitioner is not necessary for the purpose of elucidating any dispute involved between the parties in the said suit. First up, it appears to this court that the purpose of filing an application under Order 26 Rule 9 was to fish out evidence which is not permissible in law. First paragraph, the learned trial judge assigned cogent reasons for rejecting such application. So this court is not inclined to interfere with such order. Accordingly, CO number such and such stands dismissed. There shall be, however, no order as to call this. Yes, call the next matter.
I am the petitioner, my lord. This is for expeditious disposal of only the injunction application, nothing else, my lord. Not the entirety of the suit, my lord. That injunction application filed on 3rd April 2023, ad interim injunction passed on the same date. Only the expeditious disposal of the injunction application itself, nothing else.
Who are you?
Plaintiff, my lord.
Yes, there are pending applications.
Order 1.
Service is not complete.
Order 1 Rule 10 has been allowed.
Service is not complete.
Only the added defendant, my lord. That
Yes, yes. Do that. Nobody knows what happens. This application under Article 227 of the Constitution of India is at the instance of the plaintiff praying for a direction upon the learned Civil Judge Senior Division, First Court, Tomluk, District, Purbo Medinipur, to dispose of the application, to dispose of title suit number 68 of 2023 expeditiously. First up, the learned advocate appearing for the petitioner submits that an application for injunction is pending and a direction be passed to dispose of the same expeditiously. So after going through the order sheet, this court finds that 10th of June was fixed for service returns and for acknowledgement due. So it appears that the suit is not ready by way of appearance, as the summons of the suit is yet to be served upon all the defendants. For such reason, this court is not inclined to pass any directions for expeditious hearing at this stage. In the above observations, CO number such and such stands disposed of. Yes, call the next matter.
Only thing, my lord, will kindly come to the order date 20th February 2025. This is only on the added defendants. The other defendants, only the injunction application. If some direction, not time bound, my lord, just
no. Let the suit be ready thereafter. Yes, next.
Your Lordship, this matter is for the expeditious disposal of a maintenance application filed under section 36.
Expeditious disposal of?
Maintenance application filed under section 36 of the Special Marriage Act.
36.
This application was filed on 20th August 2024 before the Unit Additional District and Sessions.
Have you filed the affidavit of assets?
I have filed it. The opposite party is yet to file.
What is the next date fixed?
13th August 2025.
20th of August?
13th August.
So 13th of August. For
further hearing and for the filing of the affidavit.
For filing the affidavit of assets by the husband. This application under Article 227 of the Constitution of India is at the instance of the wife praying for a direction upon the learned Additional District Judge, First Track Court, Chandanagar, District Hooghly, to dispose of the application under the application for alimony filed under Section 36 of the Special Marriage Act, being MJC number 18 of 2024, expeditiously. The learned advocate appearing for the petitioner submits that the petitioner has filed the affidavit of assets and liabilities. When did you file the affidavit of assets and liabilities? Have already filed the affidavit of assets and liabilities, and 13th of August 2025 has been fixed for filing of the affidavit of assets and liabilities by the husband opposite party N.
2025. Order dated 23/5/25. 23rd, 2025.
First up, paragraph, in view of the order sought and proposed to be passed, there is no necessity to direct issuance of any notice upon the opposite party. First of, however, the learned advocate appearing for the petition shall be obliged to forward a copy of this application along with this order upon the opposite party or upon the learned advocates representing the opposite party before the learned trial judge. First up, in the light of the submissions made by the learned advocate for the petition, CO number such and such, stands disposed of with the hope and trust that the learned additional district judge, first track court, Chandanagar district, Hooghly, shall make an endeavor to dispose of the application for alimony pendentiality being MJC number 18 of 2024 as expeditiously as possible without granting any unnecessary adjournments to either of the parties. Yes, call the next matter. Yes.
Just small suit for declaration and permanent injunction. Filed injunction obtained not to interfere with the peaceful possession and running of the business.
Show me the order of injunction. What is the impugned order?
Impugned order is the order granting police help for implementation of the order of injunction. Lordship will kindly take the.
Who are you?
I am the person who I am actually sued between two brothers.
You are not a party in the suit.
I am the party in the suit.
You are the defendant or the plaintiff? Defendant.
This is I am suffering this order. Lordship will kindly take up the last page, second last page of my Lord's brief. Order dated 15/5/2025.
Second last page or the last page?
My Lord's brief. I am talking about a certified copy. My Lord, order is 15/5/2025.
Yes.
Lordship will kindly allow me to place it before my Lord. My Lord, I am reading. Learned advocate, third line. Learned advocate of plaintiff submitted for police help to maintain the order dated 18/12/2024. Learned advocate for the defendant raised strong objection. Pursued the record, considered. It is alleged that the plaintiff, that in spite of order of injunction passed by this court against the defendant is violating the order dated 18/12/2024 passed by this court. It is the duty of the court to see that the order has been properly implemented. Parties to the suit in true spirit and sense. Accordingly, the OC so-and-so is hereby directed to see that order dated so-and-so passed by the court in the suit is implemented properly. All concerned accordingly in its true spirit and sense. Let the copy. Now, Millard, what was the order of injunction? Just before this, Millard, the page is there. Now, Millard, I'll amplify it. Now, Millard, as far as 151 is concerned, for implementation of order, now, Millard, when police help is to be granted, Millard, it's a settled principle that police help can be granted. But, Millard, what are the tests? Millard, that the court should be satisfied that the parties are bound by the order are not in dispute. The court is satisfied that the party bound by an order of injunction has violated and disobeyed the same, thereby causing grave and serious injury to the adversary, and ends of justice will be fulfilled. Now, Millard will kindly see what is the factual matrix of this. A suit is filed. It is a suit between two brothers. They are owning the same plot of land, which is a longer plot of land. Now, in which my brother, the plaintiff, is also having certain portions, and this is my shop.
What is the nature of the property?
Shop room, Tultul Handa. Defendant was running that shop room, and I have got all the documents since 2003. Now, Millard, he files a suit saying that I am interfering with his running of the business in respect of the same shop. Suppressing material facts, he gets an order of injunction saying that he is in possession, he is running business, showing trade license or certificate of enlistment only of 2024. Only 2024. Electricity bill, because he is also the co-owner of the premises. So, electricity bill was around 10 years back, but the trade license is of 2024. Now, Millard, ad interim order of injunction granted. Subsequently, I enter appearance and I file my written statement. In my written statement...
No, written statement is another thing. In the injunction, have you filed any written objection to the injunction application?
Yes, all the
no, you are
documents.
saying written statement. That is why.
I'm just trying.
Written objection to the injunction application, you are filed. What is the next date fixed for the injunction?
My Lord will kindly, and in the meantime, when he files 151 before the trial court, he comes up to this honorable court Before this honorable court, he admits in a writ court jurisdiction that he is not in possession. And then in the petition under section 155 for police help, he says that he is in possession. And police order is granted without taking into consideration my objection with all the documents of my possession.
No, in the police help application,
Yes, my lord.
it was a contested one.
No, it was not I was not made a party. My lord will kindly say. My lord will kindly see. Police help before the trial court was
No, the honorable advocate for the defendant is saying.
Yes, my lord. Yes, my lord. I am coming to that only. My lord will kindly come to my objection under section 155.
155 or 151?
Written objection to page 81. My lord will kindly take.
Page 81.
Okay. Doctor has got.
Yes.
My lord, first, my lord will kindly take up page 74, which is their application under section 151.
Yes.
If my lord allows me to place, this is the order of injunction which they have placed in paragraph 2. Bold, that the defendant and his men and agent are hereby restrained from disturbing peaceful possession of the plaintiff in any manner whatsoever till 16/1/2025. Then, my lord, next page he says, paragraph 4, that despite of knowledge of the order and its spirit, the defendant and his men.
Which page?
My lord, page 75 is the order.
No, you said page 81.
My lord, 75 is the 74 is the application for 151.
Yes.
Where he intends to implement this order by police. Now, my lord, at page 75 in paragraph 4, he says that I am trying to interfere with his possession with my wife and children.
Yes.
Then again, he says that he has lodged a police complaint in the next paragraph, additional to paragraph 4, and a police case has been registered against me. Then, my lord, he says that for maintaining peace and tranquility, my lord, and contempt of court, his possession should be protected. And subsequently, at page 76, my lord allows me to read paragraph 6, that if the solemn order of the learned court are violated, and if the defendant and his men are not properly restrained in this stage of violation, the defendant will be more crime prone and will have less regard to the sanctity, and then he's wanting police. So that's not to interfere with his possession. Now, my lord will kindly come. In the meantime, after filing this application, he moves a police in action before this honorable court where I was not a party. This person. After that, now my lord will kindly come to that order where it has been admitted by him.
Page.
I'm coming. My lord will kindly come to page 64.
Page
64. Yeah, my lord, I was a party. And what was the submission made?
Here he was a party.
And I was a party. But my lord, at page 24, my lord has got page 64.
64.
Now, my lord will kindly come to the same page, last paragraph. That said interim order was extended, but in the meantime, the private respondents flexed their muscles and took possession of the grocery shop. In 151, which is decided later, before that, it is a finding of the court that he is not in possession. The private respondent flexed their muscles, that is me, defendant, and took possession of the grocery shop concerned, thereby violating the order of civil court. Then, my lord, if my lord kindly comes to the page 65, last but one paragraph, I have considered the submission of the respective party, and as it has been informed that the application under section 151 of CPC is pending before the civil judge in respect of the rendering police assistance for violation of order passed by the civil court, I am of view that if the civil court directs the police authorities to act in a particular manner, thereby rendering police assistance. So, my lord, as on 24 to 25, he has admitted he is not in possession. Rightly, wrongly, indifferently. Now, my lord, as far as what I had placed before my lord, 151 application, my lord, he says that he is in possession.
74.
74, my lord, if my lord kindly comes. Page 74, my lord, he says that he is in possession, which I had placed before my lord in 151. Total departure. Now, my lord, if my lord kindly comes to my objection to 151 application, that is page 81.
81.
But 81 of my lord's brief.
Yes.
If my lord allows me to place before your lordship.
Is 83.
Yes, lordship.
Marked portion.
Lordship. I am sorry. I'm sorry, Milord.
At times it helps, Mr. Trivedi.
I know, but it is not the protocol which should be maintained. The defendant states that he is the owner of the shop room under the name and style of Tultul Bhanda and has been.
But Mr. Trivedi, have you filed any application for vacating or order objection to the injunction application?
My lord, we have filed a written statement.
Written statement is against the suit.
Why?
Why have you not filed written objection to the injunction application?
What happens? Just on the day when the matter was going to be extended, he filed this 151 application. So I did not get a chance and I filed my objection to this 151. And in this particular objection, I annexed all the documents of my possession, which were not considered by the learned court. But my lord will kindly, my lord.
When this was filed, how do I get the date that you have filed this on that date?
My objection.
Yes.
My lord will kindly come to the order
March.
sheet, my lord. In the objection will come page 81, my lord. 25/3/2025, page 81.
So you have filed it before this, before the hearing.
Yes, sir.
Before the hearing.
No. My lord will kindly see they have filed there. My lord will kindly come see.
Yes, Mr.
Filed
Trivedi, this impugned order was passed on 15th of May, 2025. So 151 objection was filed prior to that.
Yes, my lord.
That is what I am asking. Yes.
It was prior to, and all my documents have not. But my lord, my lord, before declared. Yesterday I came helter and skelter before your lordship. What I have learned, it was affirmed. My client was here, affirmed. He filed it. When he went back, he informed me at night that the police has implemented the order, and by breaking open his padlocks, possession has been handed over to the opposite party plaintiff. Now, my lord, as far as that one, so now it has come, that order has been given effect. My lord, what I am humbly submitting is, my lord, though it is, my lord, may call for a report from the police, and my lord, may ask you to serve.
By the order impugned, the application under section 151 of the Code of Civil Procedure was allowed, thereby directing the officer in charge, Nodakhali Police Station, to see that the order dated 18th of December 2024 passed in title suit number 2113 of 2024 is implemented properly by all the concerned according to its true spirit and sense. After Mr. Trivedi, learned senior advocate appearing for the petitioner, submits that written objection to the application under section 151 of the Code of Civil Procedure was filed on March 25, 2025. That is long prior to the date fixed for hearing of the application under section 151 of the Code of Civil Procedure. He further submits that pursuant to the impugned order dated 15th of May 2025, the officer in charge, Nodakhali Police Station, broke open the padlock of the
Page 118, they had given me a notice. Only
broke open the padlock of the suit property, and after dispossessing the petitioner from the suit property, has handed over possession to the opposite party hearing. First up, in view of the serious allegation made by the petitioner against the officer in charge, Nodakhali Police Station, this court directs the officer in charge, Nodakhali Police Station, to appear before this court personally tomorrow, that is Calcutta date at 10:30 AM explaining now and file a report as to what steps were taken by him pursuant to the order dated 15th of May 2025. First up, petitioner is where are the parties?
Well, parties are one, Noda Khali, no. Well, it is Noda Khali district 24 Pargana. One party, one opposite party. Mohibul.
How soon can you serve?
But today it's already, we are at 2:30. But even if we send it by speed post, because personally he will not take. But will it be my lord's pleasure to keep it day after tomorrow? Because that will also become easier for us to serve this communicated order.
Then let it be on Friday, otherwise.
Because my lord, it will be server, then we'll communicate. And since my lord is wanting,
then the তাহলে এই পুলিশের ওটাকেও শুক্রবার করে দিন। Petitioner is directed to serve a copy of this application by registered speed post with acknowledgement due and file an affidavit of service on the next date. First up, list this matter under the heading for orders on Friday at the top at 10:30 করে দিন, at 10:30. Yes. Mr. Trivedi, you need not wait for the server copy because it might take some time. You communicate this.
Communicate. I'm great.
Yes.
I'm appealing for the petition. Last
Yes.
petition was.
Yes, where is the other side? Yes. Yes, who are you? Plaintiff.
I'm for the, I'm the plaintiff.
Yes. What is the suit for?
Yeah, I'm getting
What is the suit for?
specific purpose of contract.
Yes. Where is the plaint?
Well, at page number 10.
Where is the written statement?
The statement, my lord, was not annexed, my lord, to this protocol.
No, no.
Last petition. Here is the petition. Last petition, you
My lord, paragraph number 9 onwards, my lord, is my case.
Why this dot dot? Why this blank?
No, this was subsequently filled up, my lord. It was subsequently filled up, my lord. In the copy, my lord, filed before the learned court, my lord, it was filled up, my lord.
How do I know what is the copy? But this is the service copy. He's the plaintiff. You have served him a blank copy. Where is the filled up copy?
Well, this was filed in 2014, my lord. Something. But I have a.
If the main The main point is he has stated in paragraph 9 that that the loan was.
Where is your application for handwriting expert?
It's 20 over. My lord, page number 20.
20.
20, my lord.
Evidence একটা দিন তো। পুরনো এভিডেন্স একটা দিন। You have a copy of the evidence? Yes, yes, Mr. Banerjee.
My lord, kindly considers, my lord, the impugned order once, my lord. The learned, it's not that, my lord, the learned court has not made up the mind, or, my lord, the learned court is not sure about the, my lord, the fact. My lord, the learned court specifically comes to a conclusion. Whether, my lord, the conclusion is right or wrong, my lord, my learned friend, my lord, has an opportunity, my lord, in the argument, my lord, to place my lord, the other evidences would also be relied upon.
What are the other evidence will be relied upon? To prove the signature, whether it is signed by you or not? What are the other
My lord,
materials?
even if, my lord, a commission, my lord, a handwriting expert's report comes, that cannot be, my lord, solely a ground, my lord.
Let that come. That will be considered along with other evidences. It's only a piece of evidence, and court is the expert of all experts.
That is exactly, my lord, my argument is, my lord, court has already come to a particular finding. Therefore, my lord, to negate that, my lord, it's not that, my lord, the court is inconclusive.
Section 73.
73, my lord. The court is conclusive, my lord, the court has, my lord, come to a finding, my lord, and my lord.
Anything more, Mr. Banerjee?
No, my lord.
Thank you. This application.
My lord, relied upon, my lord, I've brought a judgment, my lord, on this principle, my lord, I need not, my lord,
No, no, please rely upon.
No, no, my lord, kindly, my lord.
Please rely upon that. Don't take the risk.
I also have given 3 judgments. I have also given 3 judgments on the first.
Oh, you have given judgments?
I've given that.
Which judgment?
3 judgments of the first day I gave.
I have not called upon you. Then, yes, you are the petitioner. Yes. What are the judgments you have relied upon? There is no judgment here. What are the judgments? It's not even noted here. What are the judgments you are trying to rely upon? Yes, Mr. Banerjee, give me your judgment.
But paragraph number 12, my lord, I have relied upon that, my lord. The report of the commissioner, my lord, could only be an aid, my lord, to the trial in arriving at a finding, my lord. The trial could. This cannot be, my lord, a conclusive piece of evidence.
Yes, yes.
That is settled, my lord. Lordship, my lord, knows better than me, my lord.
No, no, no. Yes, patch out your judgments in the meantime and hand it over. This application under Article 227 of the Constitution of India, Ashun, this application under Article 227 of the Constitution of India is at the instance of the plaintiff and is directed against an order being number 61 dated March 24, 2025, passed by the learned civil judge, Junior Division, Second Court, Alipur, in title suit number 158 of 2013. First up, by the order impugned, the application filed by the petitioner under Order 26, Rule 10, capital A of the Code of Civil Procedure, praying for appointment of a handwriting expert for comparison of the signature of the defendant / opposite party herein with the signature with her signature appearing in the agreement for sale. First paragraph. The learned advocate appearing for the petitioner submits that the petitioner that the opposite party herein entered into an agreement with the petitioner for the purpose of sale of the property in question. First up, he submits that in the evidence, the defendant / opposite party herein stated that the signature of the where is that evidence?
Last occasion.
Yes, last occasion you have handed up. Where is that? Oh, I have got the judgments. I've got the judgments. Where is the cross-examination? You have taken back the cross-examination.
It is like his, but not like his signature. Like his signature.
Where is that part? He says, like my signature, but not my signature. Where is that?
Next page of it is like my signature, it is not my signature.
Where is that? Kivalam, in the cross-examination, that in the evidence, the DW1 has stated that the signature on Exhibit A is not her signature. First up, paragraph. Mr. Banerjee, learned advocate appearing for the opposite party, submits that the learned trial judge has compared the signature of the defendant appearing in the deposition sheet as well as other documents with the signature appearing in the agreement for sale, and has observed that these signatures as appearing in the agreement for sale has compared the signatures has compared the signatures of DW1 in the agreement for sale as well as in the deposition sheet, and observed that two signatures are different and the person appearing as DW1 did not sign on the document marked as Exhibit A. Full stop. Paragraph. The petitioner filed a suit for specific performance of contract wherein it has been stated that the opposite party herein was in need of money and for which he executed one agreement for sale with the petitioner for selling the property on 18/12/2002. First up, the opposite party herein in the written statement written statement I've given it to you. No?
I've given it.
Yes, you have given it. Oh, dollar. The opposite party in the written statement has specifically stated that the plaintiff and her husband compelled the defendant to sign in some blank/stamp papers, and the plaintiff with a malafide intention has converted that paper into the alleged sale agreement. First up, after going through the case made out by the opposite party in the written statement, it appears to this court that the opposite party admitted to have put her signature on some blank/stamp papers, which, according to the opposite party, was converted into the impugned sale agreement. First up paragraph, it is not in dispute that the section 73 of the Evidence Act permits the court to compare the admitted signature with the disputed one. First up, and for such purpose, the court may also direct any person present in court to write any words or figures for the purpose of enabling the court to compare the words or figures so written with any words or figures alleged to have been written by such person. First up, paragraph. Section 45 of the Evidence Act states that when the court has to form an opinion upon a point of foreign law, or of science, or art, or as to identity of handwriting or finger impressions, the opinion upon that point of persons specially skilled in such foreign law, science or art, or in question as to identity of handwriting or finger impression are relevant facts, such persons are called experts. First up, thus the comparison of handwriting expert being a thus this court is of the considered view that even though the court has the power to compare the admitted signature with the disputed one, but in order to form an opinion in this regard, an expert ought to have been appointed, more particularly in view of the allegation, in view of the specific defense case that the defendant put her signature on some blank papers, which was subsequently converted into the impugned sale agreement. First up, paragraph. For such, it is also well settled that the opinion that the report of an handwriting expert will is only a piece of evidence which will be considered along with other evidences at the time of final adjudication of the suit. Full stop, paragraph. For such reason, this court is inclined to interfere with the order impugned. Full stop, accordingly, the order impugned stands set aside. Full stop, the learned trial judge, the application for handwriting expert stands allowed. Full stop, the learned trial judge is directed to pass consequential orders in terms of this order, in terms of pursuant to this order, by sending the disputed signature and the admitted signature to the handwriting expert to be appointed by the learned trial judge pursuant to this order. Full stop, with the above observations, CO number such and such stands disposed of. Yes. Take back the copy of the evidence, but keep the written statement. Do you have any copy of the written statement? Yes.
Your Lordship, I appear on behalf of the petitioner. I am being led by Mr. Aniruddha Chatterjee, who is on his legs before court number 11. Lordship,
Accepting adjournment, anything?
Lordship, kindly
Yes.
make it not today, Lordship. I have this is
Regarding the statutory notices.
On the prayer of the learned advocate for the petitioner, hearing of the civil division application stands adjourned. Yes, next.
Yes, sir. This matter are the opposite party.
Yes, who is for the petitioner? You are for the petitioner, yes.
But while Anand went to grab the
First, what happened with the second appeal? Dismissed.
Dismissed.
10 pages order.
10 pages order.
But kindly see.
Not a speaking order.
Yes.
Speaking order.
Well, speaking order. Well,
Yes.
kindly see at a glance.
Yes. So, what was the impugned order, Mr. Ghosh? Police help allowed. Police cost to be put in. So now you have exhausted all the forums. For that, I have adjourned that. Anything more? Ashun. This application under Article 227 of the Constitution of India is at the instance of the judge, is at the instance of the decree holder. No. Defendants. Who are you?
Judgment.
Decree holder filed an application under.
That was allowed. He has challenged.
Yes.
Is at the instance of the judgment dated and is directed against an order dated May 3, 2025, passed by the learned civil judge, Junior Division, Bidhannagar, District 24, Pogonas North, in this case number 47 of 2023, arising out of ejectment execution case number 11 of 2022. So by the order impugned, the application for police help, the application under Rule 208 of the Civil Rules and Orders stood allowed. Full stop. Paragraph. When this matter was taken up for hearing on 12th of June 2025, the hearing of the civil revision application was adjourned to enable the petitioner to move the second appeal, which was pending. First of the learned advocate appearing for the petitioner in the submits that in the meantime, the second appeal stood dismissed by a judgment and order dated June 24, 2025. First up, in view thereof, this court is not inclined to since the in view thereof, this court is not inclined to interfere with the order impugned. First up, accordingly, CO number such and such stands dismissed. There shall be over no order as to cost. Urgent for the certified copy. Yes, call the next matter.
My lord, I am appearing on behalf of the petitioner, my lord. My lord, my information is that, my lord. My lord, my information is that, my lord, the matter is going to be settled on compromise, my lord.
Going to be settled?
Yes, my lord.
That is also your instruction.
My instruction is
to settle. Why?
Well, my instruction is that it allowed me.
You are the petitioner.
I am for the petitioner.
What is the order impugned?
Impugned order is this, my lord.
Injunction. Oh, preemption. What happened?
Thereafter, preempted,
That was also dismissed.
allowed.
Preemption allowed.
And the preempted.
How much time you want? Let it go out of the list with liberty to bench.
Yes.
The honored advocate appearing for the petitioner submits that talks of settlement are going on between the parties. Full stop. In view thereof, let the civil division application go out of the list. Full stop. Yes, next.
Liberty to mention, my lord.
That liberty is always there. Without liberty, you are not mentioning. Yes.
On behalf of the
I will remember that then. Yes.
My lord, on behalf of the petition, my lord. My lord, my application for order 26 rule 9 was been rejected for the reason, my lord, the application they set out was a premature, the learned judge has said. Secondly, my lord, it is difficult to determine from the evidences that is documentary and the oral to determine whether that was a dispute could be ascertained, my lord. The thirdly was in regard to, my lord,
what is the suit for?
My lord, the suit was for partition, injunction, and declaration, my lord, and that was contested, my lord.
What is the necessity of local investigation? What for?
Already in WS as well, the injunction was there. They filed up the WO where they themselves have stated, my lord, they have encroached around 122 square feet. That was an evidence they had adduced already. That in the dispute, my lord, the prima facie.
What can be done in the partition suit? Passed, declaring the shares. Thereafter, allotment will be according to
the
the shares.
construction is doing. When they were doing the construction in 21, the learned court has passed out an order that is on the peril they are going to do it. They are going to demolish, my lord. It is in page number 29.
That is a different thing altogether. If they are making
have encroached more than that, my lord.
in violation of an order of injunction, take steps. Why local investigation?
But my lord, that has to, when I am aware of my demarcation, when they have already admitted, my lord, I'll place out one judgment, my lord, in a coordinate bench of Bombay High Court also and the Supreme Court, my lord.
Bombay High Court may not be binding.
But they took down the order of the Supreme Court, my lord. One Supreme Court order passed by on
for what proposition?
My lord, on the order 26 rule 9, my lord.
On 26 rule 9, what proposition?
My lord, when an evidence has been adduced by them,
yes,
if they have accepted in the WS and WA, when they have accepted that we have encroached and the construction is taking place, in that case there is a evidence.
If there is acceptance, there is no dispute. Where is the necessity of local investigation? You get a decree on the basis of admission. Where is the necessity of order 26 rule 9 then?
But my lord, my land is more. But my lord, land is more been encroached. Not 122.
According to you, they have admitted that. So you get a decree on admission.
But 122 is not there. More than that, my lord. Around they have taken more than.
Show me that case made out in your plaint.
My lord, they kindly take out at page now 61, my lord.
Yes.
The WS what they have said, my lord. 61. The WS is there.
Yes.
In the 61, it starts out 68, my lord. Sorry, my lord. 67. 67, my lord. Sorry, my lord. সব প্রথম প্রকাশে পায় যায় নালিশি দাগে পূর্ব দিকে.
All right, I am going through this.
And thereafter, my lord, at the 16th line, 16th, 16 line, there also they admitted into that. Even in the W, where they have filed out the injunction, my lord, at page number 58, my lord.
No, their allegation is that you are enjoying more. You are enjoying more.
No, my lord. They have admitted. Even in the W also can be taken. My lord, at the page number 16 also, they have admitted, my lord. My lord, the page order sheet of 29 can also be taken, my lord.
Petitioner is directed to serve a copy of this application upon the opposite party and file an affidavit of service. The next date lists this matter under the heading contested application in the monthly list of September 2025. Yes, next.
I am for the petitioner in this one.
Yes.
But after 34 years, that I am successful in killing my lord 5 commissioners, partition commissioners. The 6th commissioner was appointed, he submitted report and he died.
6th also died?
6th also died.
It is better not to appoint any other partition commissioner.
Now, my lord, I have filed.
There must be something there for which it's advisable not to appoint any other partition commissioner. You amicably draw.
He said before the court that we are accepting the 5th commissioner's report. We have not no objection against that report, but
No,
not,
5th, what happened? 5th
he also had died.
retired.
No, died.
He also died. No, 5th submitted, died
Yes.
after submitting the report.
I am told, my lord, that 5th mara gache to. Mara gache.
Then what happened? Why the 6th commissioner then?
Because my lord, the 5th commission. Lord, the 5th commissioner's report was not rejected by the learned court. Then Lord, the 6th commissioner was appointed.
Yes. So now how can the 5th commissioner's report be accepted now?
That is not that proposal, Lord. I gave it to the court, Lord. It was not accepted. Now, Lord, the 6th commissioner, he was cross-examined. Now the question comes.
Who is opposing you, Mr. Bose?
No. Lord, he is with us.
Mr. Bose is with you.
Yes, Lord.
Yes. There is any no caveat.
There's no caveat.
Now what do you want now?
Now, Lord, the learned judge said, Lord, if your lordship kindly have a look at, Lord, the order 26 rule 10 and, Lord, the distinction between, Lord, order 26 rule 14. Because order 26 rule 14 doesn't talk about, Lord, that, Lord, the commissioner of partitions report has to be accepted after, Lord, the examination of the commissioner, which is, Lord, contra distinguished in
Order
10-2.
26, 10-2 also not that. 10-2 says report will automatically form part of the record and shall be an evidence. But you have a right to cross-examine.
Yes.
It does not say, it's not the other way around. It's not acceptance after cross-examination. It will be an evidence in the suit, form part of the record automatically. But you have a right to
And
cross-examine.
that is not there in 14. The 14 says that if there is an objection, then the court is to discharge that objection. Let 14.2.
Yes, so it's the other way around. Here, after objection, then
So, Lord, in respect of a partition commissioner, whether
pass a decree here. Court has to pass a decree on the basis of that commissioner's report after considering the objection.
no, we are not on a different point. Lord, the learned just said in the impugned order that although you have cross-examined in part, but the objection tendered by my client and the other defendant will be considered by the court, and there is no necessity of appointment of another commissioner. Now, Lord, whether, Lord, when
I
a
think that is
commissioner
the best view.
But in the present circumstance, Lord, I agree to it.
Yes.
I agree to it.
Why are you challenging this?
But no, because of, Lord, that whether, Lord, the law is such that when a partition commissioner tenders a report subjected to cross-examination, whether, Lord, the court can discharge, Lord, the objection to the report filed by the parties.
Mr. Mukherjee, what can be done?
But
Then
it was
another-
started with a cross-examination.
Yes.
We could have understood that, Lord, the court has said by exercise of powers under 14.2 to say, well, all objections against the report will be discharged by me by looking into it. That was not done here. In this case, Lord, he was
Is the
subject to
law, Mr. Mukherjee, if a witness comes, he adduces his evidence and was cross-examined in part, thereafter, but not in full, he dies. What is the effect of that evidence?
That particular evidence will be put on, will be kept on record. It will never be expunged. And Lord,
court will consider
the probative value of that
at the time of.
Now, Lord, here,
Same
Lord,
thing here. So the objections will be there. Court will consider that.
The my lord, the objections are there, whether those objections can be my lord established without cross-examining my lord, the author of the report. This is my lord where we are.
Is a fresh commission.
That is, that is.
I think you should not invite that.
I am now inviting, I'll tell your
previous-
lordship, I'll tell your lordship. My lord, I am inviting the other side to come and I'll request your lordship to send them to mediation because my client, there are my lord 6 parties, excepting one, all are willing
about the
for a,
mediation. Are you personally hopeful about the mediation?
yes, yes. 5 of my lord the parties, they are my lord willing to settle one way. Only one is my lord opposing. It can be settled. If we cannot somehow persuade that one person to think otherwise. And Lord, this point of law is also to be decided by your lordship, whether in a partition commissioner's Lord report, whether Lord the partition commissioner is to be Lord cross-examined or Lord
Mr. Mukherjee may not be in this case, considering the previous what has happened. May not be in this
but
case.
but that is not the sole
May not-
question here.
I
The
appreciate.
point of law is not that.
I understand that, but the difficulties.
The facts may be not. Yes,
history
I
that you have given
The
may not
facts
be
are
in this
peculiar.
case. Yes, show me the impugned order that
Yes,
part.
your lordship will kindly come to the. But page, page.
Mr. Mukherjee,
Pages,
Mr.
থাকে না?
Mukherjee, Lanet, senior advocate appearing for the petitioner, may be justified in arguing that the Lanet trial judge ought not to have accepted the commissioners, accepted the report of the partition commissioner. No, ought not to have accepted, ought not to have observed that the partition commissioner's report will be considered for acceptance only after giving an opportunity of hearing all the parties when the partition commissioner could not be cross-examined by the parties. By all the parties or by you?
No, 2 defendants. My client is
By
defendant
2 of the
over-
defendants.
2 sets of
By
defendants.
2 sets of defendants.
But may I use a supplementary affidavit? My objection and not the evidences were not there in the original civil
The
litigation.
as prayed for by Mr. Mukherjee, Lanet, senior advocate, leave is granted to the
Evidence
petitioner
to
to file a supplementary affidavit. First up,
Officer,
such leave is granted. The supplementary affidavit filed in court today is taken on record. Petitioner is directed to serve a copy of this application by registered speed post with acknowledgement due upon the
number?
opposite party or upon the learned advocates representing the opposite party. To serve a copy. Learned advocates also, Mr. Mukherjee, that will be better.
But learned advocate, Lord, I'll
The
give it to
opposite
plaintiff.
parties, as well as upon the learned advocates representing the opposite parties, before the
Plaintiff
learned trial
opposite
judge.
parties. Plaintiff opposite parties.
Partition suit serve
All.
upon all.
Very well.
Upon the opposite parties appearing before the learned trial judge. First up, list this matter under the heading motion in the monthly list of August.
Lordship. We will try for mediation because my client is willing and he is also not
Kindly.
saying that.
Yes, call the fixed matters. Yes, Mr.
Get
Bakshi, which matter is yours?
But I was praying for not stay because there is a on this Saturday there is a date fixed for procedure.
There shall be an order of stay of all further proceedings. So it's number the other one till the end of September.
Lordship.
Yes, Mr. Bakshi, which matter is yours? You are for the petitioner or the opposite party? Where is the petition? Maybe because 3 p.m. some matters are fixed. Mr. Mitro, which matter? Fixed matter.
Mr. Mahathur is
3 p.m. fixed matter.
I have no difficulty, but I really did not know how.
You are the petitioner, you do not know. Who has mentioned? Let me see.
My instruction is. No, no.
Let me see. 331. 331 to nahi. 331 of the supplementary of the monthly. 331 ফাইলটা বার করুন তো উনি বলছেন উনি মেনশন করেননি
My instruction is, my lord, nobody on our side mentioned.
331 টা একটু বার করতে বলুন। Yes, Mr. Bahato, you are for in that matter. Which item?
37. 37?
Huh?
37.
37.
Today or tomorrow?
37. Oh, 3 p.m. Oh, 3 p.m. all right. হ্যাঁ তো সেটা ডাকছি আগে combined list, some combined list matters are there, thereafter I am calling. I thought Mr. Bakshi were in the regular serial. 331 টা যেটা মিস্টার মিত্র বললেন ওটা একটু ফাইলটা বার করুন তো।
My lord, I shall make it very clear. My lord, I have no difficulty in
Combined list অনেকগুলো আছে এটা হ্যাঁ combined list অনেকগুলো আছে হ্যাঁ Opposite party has mentioned. Yes, who is appearing in item number 331? ঠিক আছে 500 টাকা করে ডাকুন সিরিয়ালে তারপর দেখছি opposite party has mentioned.
My lord, only thing is,
Should have been. Mr. Mitra, it's very difficult to go through this. I'm only looking at the urgency. I'm fixing a date in the matters where,
I have no difficulty.
but
I have.
if the opposite party mentions without serving, it's very difficult.
Subsequent notice, my lord, also helps us.
If you are in difficulty, you can ask your juniors to remain. And if you can remain present, you can, because some combined list matters, thereafter I will take up. Yes, call the combined list matters. 766.
At 3 p.m. matter.
Yes, 3 p.m. There are some combined list matters, thereafter I will, those are also 3 p.m. matters. 3-4 matters I will call on. Yes.
Worship, I am for pro forma opposite party number 3.
Pro forma opposite party. Who is the main opposite party?
First time.
Oh, first time. So, Mr. Chakraborty, you are supporting Mr. Mukherjee then? Yes. What is the impute?
I'm sorry, Milord, my learned friend will not have served, Milord, in advance. Mr. Haldar is appearing. Given
Instruction to appear on behalf of the opposite party, but
Copy, you have got copy.
copy served, but no notice of application has been served up.
When this matter is taken up for hearing, Mr. Haldar, learned advocate appearing for the petition, opposite party submits that no notice for upgradation of this matter has been served upon him. So, in view thereof, let the matter revert back to its original position. Yes, next.
my instructing advocate saying that he has not mentioned even the matter.
You have served the notice.
No, notice the original.
You have not mentioned.
That for upgradation, my learned instructing advocate is saying that upgradation he has not mentioned.
Raja Mentos.
I have mentioned the matter.
Yes, please see the signature and the mentioning slip. Yes, Dakhan. Yes, Mr. Mukherjee, please look to that.
I was not aware, Lordship, this is updated only the morning I came to know.
So the way you have given the slip, on that date, this date was fixed. You are mentioning when the dates are fixed, you are saying you did not know. Yes, call the next matter. 1-1. Yes. 1-1-2-8.
I am for the petitioner, my lord.
Yes.
My lord, it's a matter of expeditious disposal, my lord. Milord, I am the petitioner, Milord. I have filed a Milord probate case, Milord, in the year of 2023, Milord. Thereafter, Milord, due to the court, initially, Milord, the court was vacant, Milord. Second, subsequently, Milord, one near relative, Milord, appeared, and Milord, the case was transferred to the second ADJ Shialda, Milord.
Article 220, this application under Article 227 of the Constitution of India. No, by this application under Article 227 of the Constitution of India, the petitioner has prayed for a direction upon the learned district delegate Shialda to dispose of the.
No, Milord. Milord has directed a supplementary affidavit what has transferred from the Milord 18th of March, Milord 2025. Milord has directed. Milord, this is the Milord supplementary affidavit I filed, Milord. In the paragraph 4, Milord, I have written the matter was transferred to Milord second ADJ Shialda. Milord, then Milord, second ADJ Shialda. Thereafter, Milord, not that much Milord developments have been looked into, Milord. Therefore, Milord, I am praying for an expeditious disposal, Milord.
The has prayed for a direction upon the learned district delegate Shialda to dispose of the probate case number 9 of 2023 expeditiously. First of the learned advocate appearing for the petitioner files a supplementary affidavit pursuant to the order dated 18th of March 2025, which is taken on record. First up, in the said supplementary affidavit, the petitioner has annexed the subsequent orders passed in
OS Milord 11 of 2024.
OS 11 of 2024, pending before the learned additional district judge, second court at Shialda. First up, the learned advocates prays for a direction upon the learned additional district judge, second court at Shialda to dispose of the OS case number 11 of 2024 expeditiously. First up, in view of the order sought and proposed to be passed, there is no necessity to direct issuance of any notice upon the opposite parties. First, however, the learned advocate on record of the petition shall be obliged to forward a copy of this application along with this order upon the opposite party or upon the learned advocates representing the opposite party before the learned trial judge. First up, from the order sheets appended to the supplementary affidavit, this court finds that 16th of April 2024 was fixed for framing of issues and 27th of June 2025 was fixed for hearing of the application under section 151 of the Code of Civil Procedure. 151 application disposed of or pending?
Milord, disposed of, Milord.
151 disposed of.
Milord, I do not have that in instruction, Milord, but subsequent, Milord, 27th of June, Milord, due to the local resolution of the bar, Milord, it was adjourned.
What is the next date?
182025.
1st of August 2025. For what?
For hearing of the petition.
151.
Yes, Milord.
The learned advocate appearing for the petitioner submits that 1st of August 2025 has been fixed for hearing of the application under section 151 of the Code of Civil Procedure. So, in the light of the submissions made by the learned advocate for the petition, CO number such and such stands disposed of by requesting the learned additional district judge, second court at Shialda to take up the hearing of the application under section 151 of the Code of Civil Procedure, on the next date, on the next date fixed, if the same is otherwise ready for hearing, and to make an endeavor to dispose of the same as expeditiously as possible without granting any unnecessary adjournments to either of the parties. So, after disposal of the interlocutory applications, the learned additional district judge, second court at Shialda is requested to make an endeavor to dispose of OS 11 of 2024 as expeditiously as possible without granting any unnecessary adjournments to either of the parties. Yes, next. This matter was mentioned, citing urgency. Considering the urgency pleaded, this matter was fixed at 3 p.m. today. However, when this matter is taken up for hearing, none appears for the petitioner. First up, no accommodation has been sought for either. In view thereof, CO number stands dismissed for default. Call the next matter. Yes.
I am the defendant petitioner My lord, this revisional application is against the order allowing the application for amendment of the plaint after a gap of nearly 10 years. When the issues have
commenced.
Trial commenced, issues have been framed.
No, issues, framing of issues does not commence
No,
trial. I'm asking you, trial commenced, yes or no?
No, trial not commenced. But it is.
What is your objection to the allowing the application under order?
My lord, kindly see the entire scenario of the suit is changed. Kindly see.
How? What is the suit for?
Suit for recovery of possession inter alia on the ground of default and reasonable requirement.
What is the amendment? Show me the amendment.
Kindly come to inner page 3, running page 30.
Running page 30.
Yes. These facts are very much within, at least 7A is within the knowledge of the plaintiff.
Maybe.
What is the family members?
These are necessary.
No, this should have been done long at the time of filing of the suit. There is no change. This is not a subsequent event.
All right. This application under Article 227 of the Constitution of India is at the instance of the defendant and is directed against an order being number 95 dated 14th of January 2025 passed by the learned judge 5th bench presidency small causes court at Calcutta in ejectment suit number 142 of 2008. To stop by the order impugned the application under order section 17 of the Code of Civil Procedure stood allowed. To stop the learned Mr. I, learned advocate appearing for the petitioner submits that the nature and character of the instant suit has been changed by way of proposed amendment. First up paragraph, the opposite party filed a suit for eviction under section 6 of the West Bengal Premises Tenancy Act 1996, inter alia on the ground of
reasonable requirement.
Only the inter alia on the ground of reasonable requirement. First up, after going through the schedule of the application for amendment of plaint, this court finds that the opposite party has sought to include the ground of subletting. Full stop paragraph after the proposed amendments are necessary for the purpose of deciding the real controversies between the parties. Full stop. Addition of a ground permissible under section 6 of the 1997 Act to the existing grounds cannot result in changing the nature or character of the suit, as the suit remains a suit for eviction under section 6 of the 1997 Act. For such reason, this court is not inclined to interfere with the order impugned. Accordingly, CO 1450 of 2025 stands dismissed. There shall be, however, no order as to cost. At this stage, the learned advocate appearing for the petitioner prays that a liberty be granted to the petitioner to file the additional written statement. Amended copy of the plaint served.
Yes.
The learned advocate appearing for the petitioner submits that the copy of the amended plaint has already been served. First, in the light of the submissions made by the learned advocate for the petitioner, CO number, I guess CO dismiss bolini to? CO number not interfere, dismissal ta boleche kina dekhun. Tale kete din. Tale ota kete din. ঠিক আছে, is not inclined to interfere, ওই পর্যন্ত থাকবে। ঠিক আছে, in the light of the submissions made by the learned advocate for the petitioner, CO number such and such stands disposed of by giving liberty to the petitioner to file an additional written statement within a period of 2 weeks from the date of receipt of a server copy of this order.
Grateful, my lord.
Call the next matter.
Yes, number 1393, I'm for the petitioners, my lord.
Yes.
So these are my affidavits of service, my lord. I have served a copy of the revisional application on the.
What is the impugned order?
My lord, by the impugned order, my lord, the learned trial court directed the petitioner husband to pay an amount of rupees 13,000 to the opposite party wife, my lord, as alimony pendenti light. Now, my lord, this amount was in addition to an amount of rupees 7,000.
What is your income?
39,300, and that has been recorded by the learned trial court in the impugned order, my lord. Kindly comes to first, my lord, page 4 of the impugned order. My lordship will find that this amount 13,000, this is in addition to the amount which has been granted in connection with the proceeding under 125 of the CRPC. 7,000 was the amount. And my income.
Where is the finding of income?
Yes, my lord, kindly comes to page 3, the last paragraph of the impugned order. Upon careful scrutiny of the affidavits filed by both the parties, it is found that the OP had a net salary of rupees 39,306 per month in the month of November 2023.
What is the amount of maintenance under section 125?
My lord, that order is also annexed, my lord. That
What is the amount? Tell me the amount.
7,000, my lord.
7,000.
That is
by the order impugned, the husband petitioner was directed to pay maintenance penalty at the rate of rupees 13,000 per month, in addition to the amount directed to be paid in a proceeding under section 125 of the Criminal Procedure Code. First up, on a perusal of the impugned order, this court finds that the learned trial judge has arrived at a finding that the net salary of the petitioner herein is rupees 39,306 per month. First up, in view thereof, there shall be an order of stay of operation of the impugned order, subject to the condition that the petitioner shall go on paying a sum of rupees 6,000 per month in addition to the amount directed to be paid in the proceeding under section 125 of the Criminal Procedure Code in the manner as directed by the learned trial judge. The petitioner is directed to serve a copy of this application by registers with
My
acknowledgement.
lord, I've already served twice. My lord, I've also filed a separate application for stay of the impugned order, that is CAN 1. That has also been served.
Sir, you have upgraded these. How do they know?
My lord, I kindly seize the second affidavit of service. My lord, the second affidavit of service I've mentioned while serving the CAN application that I would be mentioning it for upgradation, my lord. Kindly see the second affidavit of service. That is of CAN 1. I have served
That is CAN, not the main revision application.
No, my lord. There are two affidavits of service, my lord. First,
main civil revision application.
Yes. Kindly seize there are two affidavits.
Sir, have you mentioned that you will upgrade the main civil revision application?
Yes, my lord.
Where is the notice? Show me the notice.
Second affidavit of service of the CAN. Kindly seize the last paragraph. After serving the CAN application, I had mentioned that I would be mentioning it before your lordship for upgradation in the month of May. Thereafter, my lord, I mentioned it in May and June as well. Kindly see this notice in the second affidavit of service, my lord. CAN 1.
In order to afford a last opportunity to the wife opposite party to contest this proceeding, list this matter under the heading motion in the monthly list of August 2025. Service order in order to afford an opportunity.
My lord, order of
directed to serve.
Order of stay of the impugned order insofar as, my lord, both the amounts is concerned, my lord, because I am paying.
You are paying
7,000.
7,000 in addition to that, pay 6,000.
Yes, my lord.
I said 6,000 in addition to the amount you are paying.
Grateful. Lord.
Yes.
Grateful.
Yes.
A suit is for declaration of right title, interest and injunction.
What is the impugned order?
By the impugned order, my lord, the amendment application has been allowed in part. Two prayers.
Your application for amendment allowed in part, or Mr. Bakhchi's
application for amendment.
So you are agreed by the part rejection.
Sir, refusal.
Part rejection.
And that is the main part of the amendment. Well, the ground is, my lord, for rejection that they have stated certain particular facts, man, in the written statement. I have filing this amendment. I am mere denying all this. Therefore, it is not necessary. It should be rejected. That is the cause.
Sir, Mahato, is it the law that you have to file an amendment in order to deny the statements made in the written statement? Show me the law.
No, matter I have stated other.
Mahato, it will be a never-ending process.
I have
Mr.
also.
Mahato, plaintiff files a suit, makes certain allegations. You file a written statement denying, making out certain other positive case. Now, according to you, then the plaintiff will then also file another amendment application saying, yes, these statements I am denying. Then the defendant again will file an additional written statement saying something. Then the plaintiff will again say, I am denying this. Is it the law? Or what is the law?
If some
How those statements are to be dealt with?
Delay.
That is a different thing. Mr. Mahato, what is the law?
But if any new facts are brought on record by way of written statement, my lord, that is required to be countered.
Show me the law. Show me the law that is to be countered by way of amendment. Show me the law.
Either by way of amendment or by filing a replica.
No, he was given chance to add his evidence.
That is the law, Mr. Mahato. Show me the law.
Certain new facts are required.
Mr. Mahato, that is why I've given you an example. In the written statement, the plaint allegations are denied. Positive case of the defendant is made out. So, is it the law? The plaintiff has to file an amendment application saying, yes, these facts I am denying. And then he will again state something. The defendant will give a written statement, additional written statement. Then again the plaintiff will come and say, this is a never-ending process.
But if some new facts are come, I am to deal to it.
Show me the law. Show me the law.
This is not a new fact. Very
Show me
old
the
fact.
law that for denying an amendment can be permitted to deny the facts stated in the written statement. Show me the law.
Well, can you take it up tomorrow then?
Mr. Mahato, you have
No, it
mentioned
is well settled.
this is the,
Well, it
show
is
me
well
this well
Today I
settled
am
law.
not ready with that. I don't. I
That
think
is the only issue.
it is required to be produced before your lordship. I was not in that.
The law is otherwise. You have to cross-examine him. You can lead evidence. Demolishing, that's the law.
My lord,
Positive statements, when you are coming as a witness, you have to deny those things. You can also cross-examine them. But it's not the law. They will have to file that amendment to deny that.
besides, my lord,
If
your
it-
lordship.
Well settled, Mr. Mahato.
By filing replica, it is required to be dealt with.
Show me.
By filing
Show me that it cannot be said that you cannot do that by way of leading evidence.
only by during
Mr.
evidence.
Bakshi, where are those decisions?
My lord, I have not.
Amendment
My lord, kindly come to my lord. Page.
Mr. Mahato is disputing this
Bengali
well settled
page five.
proposition, please.
Bengali page 5.
Bengali, page 5.
In page 5 in Bengali.
No, you are saying
Paragraph 10.
no application for amendment. You are saying
No. Plain.
plain, not annexed, Mr. Mahato.
Yes.
No. Plain is not.
You have not annexed.
Not an
Yes, page.
Page
5.
my lord, Bengali. Paragraph 10, Bengali.
Page 5, paragraph 10. Yes.
My lord, আদি ঘটনার তার কর্মস্থল খড়গপুর হইতে উক্ত হইয়া 21 তারিখে নালিশি মৌজার নিজ গৃহে আসিলে বাদীগণ পূর্বোক্ত অভিযোগ উল্লেখ করিয়া that coercion etc. Now, my lord, see the amendment.
Yes. Now, where is the amendment application? So this is Mr. Mahato's plain.
Yes.
Now, where is your written statement?
Written statement. Oh, for yes. This is the next document, man.
Yes. Which paragraph deals with paragraph 10? Paragraph 20.
Also?
And where is your application, Mr. Mahato?
Amendment at page 10.
Page 10 of the civil division.
আর ওই জায়গাটা যেখানটা ও বলছে amendment আমরা কোথায় বললাম ওটা তো পড়ে দিলাম আর আমরা এইটাতে ওরা আমেন্ড করতে চাইছি
Mr. Mahato, I have not seen the order. Perfect reasoning. That is what I was saying. What I was saying, that's the perfect, that's the observation. In my opinion, prayer for amendment only for the purpose of giving denial to specific defense case.
Well, that is the statement, but man, kindly see the entire.
and that too, my lord,
Yes. That is the statement, you can demolish that. For that amendment cannot be permitted.
No, my lord, if, since the new facts have come, my lord, it is required. to
It is
convert.
not new fact. It is very old fact. It is not
All
post
right, if you want
fact
to bring some
post
decision. All right.
And next, my lord, delay. Delay has to be explained. Proviso. Kindly see Order 6 Rule 17. Peremptory has fallen. After peremptory.
No, when this, yes, Mr. Mahato, where is the reasoning in the proviso?
My lord,
And no delay, no expansion of
is
delay.
there. No expansion is there, my lord, but my lord, so far the peremptory hearing is concerned, my lord, the
Thank
court
you.
has just fixed for, my lord, court has just fixed for peremptory hearing.
No, not fixed.
My lord, and it's the order.
3 times were taken.
My lord, the fifth,
That is,
7th
you
April
have
2025
paid cost
P8.
to bring it out of cost.
It is not
Fixed
that
for
we-
PH. Mr. Bakshi, the trial has not commenced.
Mando kindly.
Trial commencement is when the documents are marked as exhibits. That has not come.
Yes.
That has not come. So proviso may not attract, but the
But kindly give me. Well, I was not in a, but I was under.
Mr. Mahato, I have not seen that. I gave you time for that, but I find that is the exact reasoning. If you had the decisions, counter decisions, you ought to have brought that.
First appeal, my lord, in connection with the suit for eviction, say the facts or the grounds taken by the defendant was not controverted by my client. Justice Bhattacharya, my lord, sitting in division bench. Justice Bhaskar Bhattacharya sitting in division bench.
Wrong. He is wrong. It's totally wrong. I don't read.
Therefore, my lord, can you take it on the next day?
My lord, delay is to be explained. Proviso.
Proviso, Mr. Bakshi is not attracted because the trial has not commenced.
Hearing has commenced.
No, no.
It is in the report.
It is only in the PH. Mr. Bakshi, I've seen PH. Fixing of PH does not amount to.
By bringing it out of the peremptory board.
Mr. Bakshi, this has been.
Secondly, my lord, this is not necessary.
That is a different thing altogether. Proviso may not stand attracted because there is a single bench judgment. I had the occasion to argue. Thereafter, that was followed in the division bench judgment. So commencement of trial, now it's well settled. What's the stage? So,
My lord, the Supreme Court has.
Mr. Bakshi, he is relying upon a division bench judgment. Give me some handle otherwise. I am bound.
It does not.
Mr. Bakshi, I am bound by that division bench.
My LIC judgment in Supreme Court manner says all amendments should be allowed.
All amendments should be allowed. Supreme Court will be followed.
My lord, it is said, my lord, paragraph 71.
71. Yes.
It says all amendments are to be allowed which are necessary for the determining the real question. In
Yes, yes.
Provided that it does not cause injustice or prejudice.
No,
to the
it
other.
is injustice.
This is what injustice? This is mandatory as it appears from the use of the word shall in the latter part of Order 670.
Yes.
I am aware of that proposition,
I know
Mr.
that.
I have considered that judgment. So I am aware of those propositions.
Can you take it on
Paragraph
next step, Lord?
71 exhaustively dealt with.
My lord, I have finished.
The exception is-
I have finished.
Mr. Bakshi, please give me some decisions because he will be relying upon a division bench judgment.
Unnecessary. There is no such decision. And court says that.
Next week.
Next week.
जब इच्छे तुम्हें ऐसे decision देखिए या कोई.
Mr.
My lord,
Bakshi,
I
next
insist.
week.
My
Next
delay
week,
is to be explained.
Mr. Bakshi, next week when he will be available?
When?
Next week when he will be available?
My lord, I have finished. Any date, if I come, I will come.
You remain.
My will be enough.
When, Mr. Mahato, when?
Any day, my lord. Next week, any day.
Difficulty is fixing in the next week.
And my lord, different dates, my lord, you are also.
My lord, note on the
8th July.
Dates are not different.
Yes.
What I told you.
8th of July. Ashun. Heard Mr. Mahato, learned advocate for the petitioner, and Mr. Bakshi, learned senior advocate appearing for the opposite party. First, Mr. Mahato pressed for an accommodation to place certain decisions in support of his contention on the next day. First up, list this matter on 8th of July, fixed at 3 p.m. Yes, next. ডাকুন।
This is that matter which has been mentioned without any notice to us. We are the petitioners. Well, it was not.
Yes, you are the opposite party. Did you give notice to the petitioner? You will check from whom? Maybe. Why? Why?
Because the injunction has been in my favor, against them. They have come up with this that as per the last order, I have given an undertaking before you. I am not making the property has been purchased for an amount of.
The minimum that is expected is being an opposite party when you are mentioning, you have to notify the petitioner. That is the minimum that is expected. Ashun. This matter was mentioned by the opposite party. First up, considering the urgency pleaded, this matter was fixed at 3 p.m. today. First up, Mr. Mitro Lanet, senior advocate appearing for the petitioner, submits that no notice for upgradation of this matter was served upon the learned advocate on record of the petitioner. First up, in view thereof, let the matter revert back. Yes, you are for the opposite party.
No, petition. No, petition. Leading me, madam. Petition.
Let the matter revert back to its original position. Yes. Yes.
I am for the petitioner, my lord, in this matter, led by Mr. Royan Banerjee. As per your lordship.
It's a busy counsel. He will not be available. Please don't look at the back. Yes, I start.
This is the affidavit of service, my lord.
Yes, Mr. Banerjee, that matter. What happened?
Yes.
State, have you served?
State.
State is appearing today.
Yes, yes. What is your instruction?
I asked for
Please use the microphone.
Department, my lord, I will only will request, my lord, if your lordship kindly gives me 1 week time, my lord, I'll take instructions. I have already informed them to
Let
give
them
me
take
instructions.
instruction. My submission is that
old
it is not
matter.
permissible notice. If there is no decree against
Then
that,
take it, Mr. Banerjee, if this can be sorted out, it's after all.
Submission is concerned, I'll only request lordship to
Mr. Mukherjee, you are interested in the money only.
I'm interested in the money.
Let me see. Yes. Also take instructions how soon the amount will be paid.
Yes, my lord. I will also have to take instruction whether requiring body, my learned son Sprinia has at all, my lord, placed the funds or not. But I'll also take that.
If not, if the funds are not placed, you do whatever you can, but you pay to the decree holder. So wind the corporation. Take steps for winding up of that corporation.
I'll come back with the instructions.
appeals are pending. Both at the instance of state
Yes,
as well as
state appeal is also pending. That is.
the appeal, my lord.
Appeal is pending, no stay, implement, then recover.
In the appeal, it was there was a
Then recover.
There is no stay. I cannot say. In the appeal, there is a direction to deposit, which there is not.
Pursuant to the order dated 23rd of June 2025, a notice was served upon the learned government pleader, High Court, Calcutta. First up, affidavit service filed in court today is taken on record. First up, the state is represented. First up, the learned advocate appearing for the state prays for, yes, how much time?
A week's time or 10 days, my lord.
Prays for 10 days time to take instructions. First up,
One thing, my lord. Proceeding against the state is going on. Attachment application is pending. It is fixed for hearing. Only thing, in the meantime, they gave our name and this proceeding started. Let the proceeding go as it is. But
list this matter on 10 दिन মানে আজকে কত 2 মানে 12 তাই তো তাহলে 15-16 কি অবস্থা 15th July.
Deeply obliged.
Under the same heading. Yes, call the next matter. Yes. Yes, call the next matter. Yes.
See my review application.
Yes.
My lord, I come to the order, first your lordship.
Yes.
My lord, after going through the impugned order, this court finds that the evidence of the defendant was closed as the learned advocate for the defendant submitted that the defendant could not adduce any further evidence. Therefore, the plaintiff cannot be said to be aggrieved against such order.
Yes.
My lord, I have not given any chance to cross-examine. My humble prayer is to give me chance so that I can cross-examine the defendant.
Which defendant?
Defendant number one.
Defendant number one.
My lord, for my revision applicant, yes. What is the order? My lord, agreed by this order. Order dated 4 April 2023. Order number 228. My humble prayer is to give me a chance to cross-examine. That is the only prayer.
So Kundu, your conduct is very bad.
That's true. That's true.
Conduct is very bad.
That's true.
What is the stage of the suit? The defense argument?
Argument stage.
So argument in 2023. Today we are on 2025. 17th of April 2023 was fixed for argument.
Yes.
So what can be done now?
But that is going on.
No. For 2 years.
Only give me a chance to cross-examine.
Where is you have not filed any application for recalling? How can that be done? No application for recalling.
No.
Then
That is not there.
how can that be done?
Input and cost kindly allow me.
Mr. Kundu, that cannot be done.
Conduct of the learned advocate.
Mr. I appreciate everything, but in order to give you an opportunity to cross-examine, that witness has to be recalled. You have not filed any application for recalling.
That's true.
Then
the learned advocate for appearing for the petition, he did not turn up to cross-examine DW1.
Kundu, I accept that. I follow lawyers, latches, everything. Rightly or wrongly, the evidence was closed.
Lordship.
Now you want to cross-examine it.
Lordship.
So this first step is that you have to recall that witness. No application for recalling has been made. How can I now give you permission?
Give me a chance to file that application.
That is already there. For that, no leave is necessary. Ashun. This application under this is an application for review of the order dated March 12, 2025. First up, by the order dated 12th of March 2025, this court held that the petitioner cannot be said to be an aggrieved party as cannot be said to be aggrieved by the impugned order, as by the said order the evidence of the defendant was closed, as the learned advocate for the defendant submitted that the defendant would not adduce any further evidence. Mr. Kundu, learned advocate appearing for the petitioner, submits that an opportunity be given to the petitioner to cross-examine DW1. First up, it appears from the record that the to cross-examine the PW1 বলেছি, DW1 হবে কিন্তু। DW1 বলেছি তো? It appears from the records that the that the evidence of the DW1 was closed.
My lord, I'm for the petitioner praying for not this week.
Not this
My
week
lord, the council is out of station. My lord, kindly fix after 8 July.
Yes, yes, madam, please move.
My lord, right now I don't have the brief. The it's with the council.
On the prayer of the learned advocate for the petitioner, hearing of the civil revision application. Hearing of the civil revision application stands adjourned. Yes, next. Yes.
Well, this is an application under Article 227 of the Constitution of India, my lord. We are praying for, my lord, a revision of the order dated 16/5/25 passed by the learned First Additional Civil Judge Junior Division at Alipur, my lord. In that order, my lord, the learned civil judge deferred to pass an order under Order 7 Rule 11 of the CPC on the ground that a misappeal is pending. This misappeal, my lord, arose out of title suit number 1543 of 2024 before the First Additional Civil Judge Junior Division. I am, my lord, for the petitioner and also for the defendants in that title suit, my lord. In that title suit, my lord, the plaintiffs were able to secure an injunction, and thereafter, my lord, we were able to secure a stay from the learned district judge in charge. And, my lord, the impugned order, my lord.
Where is the order of stay passed by the appellate court?
Yes, my lord. Page 70, my lord.
Page
70.
70.
Yes, my lord. If your lordship pleases to come to page number 71, my lord, that is the actual order, my lord. The gift deed does not mention LR Dag number 343. That is the mallet, that is the subject suit property mallet.
No, you are challenging this order. No.
We are challenging mallet order dated 16/5/2025 mallet. It was the day reserved for the order under order 7 rule 11 mallet. On 28/5/2025 mallet.
Interim stay.
No, mallet, we are challenging order dated 16/5/2025 mallet.
Why the suit should be stayed?
Mallet, the suit was not stayed mallet. The injunction order was stayed mallet.
Yes, but the trial court was of the view that the stay cannot proceed because there is an order of stay.
No, mallet.
16th of May, that is the order.
16, mallet, it is not because of the stay, it is because of the misappeal is pending. And mallet, if your lordship comes to page number 93, mallet, order dated 7th of April 2025, mallet.
Yes.
On that day, mallet, 16/5/2025 was fixed to be the date of the order, mallet. Page number 93.
Page number 93, yes.
Yes, mallet. The order dated 7th April 2025.
Yes, now what do you want?
Yes, mallet, right now, mallet, we are actually praying before your lordship to direct the trial court to pass an order because, mallet,
pass an order on what?
It's an order on the order 7 rule 11, mallet. It has been heard, it has been marked, mallet, but only on the ground that a misappeal is pending, mallet, it is actually deferred, mallet. And your lordship is aware, mallet, that it is settled law, mallet, that order 7 rule 11 order can be passed at any stage, mallet.
My lord, in this matter, I am being led by Mr. Ratnanko Banerjee, my lord. My lord, I believe there's a joint prayer of taking a note this week, my lord.
Your Lordship, I'm for respondent number 1. I'm led by Mr. Devnath Ghosh, Your Lordship. Devnath Ghosh had indicated last day that he will not be there in the court.
He said he will not be there for today.
Today.
And you are saying not this week.
My lord, then, my lord, may I not make it not today, my lord, then tomorrow, my lord.
All right, not today.
Grateful, Your Lord.
Grateful.
Yes. Call the next matter. Call the fixed matters. Yes.
I am for the petitioner, my lord.
Yes.
Land acquisition proceeding. Refer to district court to settlement who is the owner of the property. Matter disposed of by passing a judgment. Against challenging the same, a revision application filed before this honorable court, while, my lord, it is the appealable order. A learned court is of the view, when the division is pending, the amount cannot be discharged. In the meantime, my lord, the wife of the petitioners became a cancer patient. Huge amount died, huge amount has been expensed. Therefore, my lord, kindly a direction is necessary unless.
Where is 704 of 2024?
They have
That
filed
is my lord, item number 777. So the subsequent revisional application, my lord, is a follow-up from the earlier, my revisional application. So therefore, my lord, subject to your lordship's.
This application is that was your application.
Yes.
These two are to be heard
Heard
together.
together.
Yes, my lord.
Ashwin. List this matter along with CO 704 of 2024 in the monthly list of July 2025.
Analogously, my lord.
Yes, next.
Opposite party.
Yes, none appears for the petitioner at the none appears for the petitioner at the time of call. No accommodation has been sought for either. For the ends of justice, hearing of the civil division application stands adjourned. Yes, next. তাহলে এটা কোনটা এটা তো তাহলে তাহলে এটা অর্ডার রেকর্ড করো ও পরেরটা তা ডাকুন একবার তারপর already not today. Next. None appears for the petitioner at the time of call. No accommodation has been sought for either. For the ends of justice, the hearing of the civil division application stands adjourned. Yes, next.
My lord, I am for the 1038 to 1041. My lord, I am pleading.
1038, why did you not respond?
My lord, I'm sorry, my lord.
Yes, yes.
My lord, I'm praying for the short Passover, my lord.
Passover business is 4-5. Yes, please start.
My lord, my senior is on the way, my lord. Just a short Passover.
Yes, not today. Next.
But we are for the opposite participant.
Yes.
We are for the opposite party. The petition is not appearing. This was mentioned by the petitioners. We were informed.
This civil division applications none appears for the petitioner. 1038.
1038, 1039, 40 and 41.
1038 to 1041 আলাদা করে order করে দিন. None appears for the petitioner at the time of call. No accommodation has been sought for either. The opposite party is represented by the learned advocate. First up, in view thereof, the hearing of the civil division application stands adjourned. Call the next matter.
Deeply acknowledged.
10. Yes. Then yellow. Same order, none appears. Hearing of the civil division application stands adjourned. Yes, next. 1082. Yes, 1082. Who is appearing?
nine.
1084 না 82 1082 তো রয়েছে 1082
ঠিক আছে।
1038
হ্যাঁ ঠিক আছে।
কল হয়ে গেছে
ঠিক স্কুল
কখন কল
এই তো কি বললাম
103
38 39 40 41 দেখেছি
1038
You are not there, other side was there, it has been adjourned. 1038 to I think 1041. That I do not. It's difficult, Mr. Bhagath, all days have been fixed.
What happened in this case, they have filed a repairing petition for 1 year. They are
You can bring the other side, I can take up. He has just now left. Din, file ta din. 1162. 1082 টা কি হলো? Yes. 11. Yes, same order. Stand adjourned. Next. Same order. Stand adjourned. Next. Same order. Stands adjourned. Next. Same order. Stands adjourned. Yes, next. Same order. Stands adjourned. Next. Yes, sir.
Is the pathetic situation has been occurred, my lord.
Yes,
Since
yes.
long, petitioner is fighting to get only repairing, nothing else.
Yes, yes. What is the matter? Please move.
My lord, I have challenged the order. My lord, first I am submitting the affidavit of service, my lord.
Affidavit of service.
Lordship.
Did you give any notice for mentioning?
Lordship.
For upgradation? Where is that notice?
Lordship, I last Wednesday, Lordship, I
Where is that notice?
raised the notice before your Lordship, and Lordship allowed the matter and fix in the bottom portion of the today's list. Upon notice, my lord, I mentioned the matter on that day.
Yes.
Lordship, I have challenged the order dated 26 April 2024, where, my lord, I placed one application for order 39 rule 7
Yes.
for inspection and submit report before the learned court below, so that I get the repairing of my house. Petitioner, my lord, actually widow woman and doing maid service door to door. It is, my lord, not possible to stay at that position, my lord, which picture showing, my lord, in page number. I have attached the picture also. My lord, at the time of moving the application order 39 rule 7, my lord, I have traced the Aadhaar card which is showing the address.
Where is your application on order 39 rule 7?
Lordship, that has been attached with the
Where is the repairing application?
Lordship, that
Have you filed any repairing application?
Lordship,
Where is that?
Lordship, Annexure 4, Milord.
Where is the application?
Lordship, Annexure 4.
No.
That
P4 is the application for local inspection. Where is the application for repairing?
Lordship,
Where is that?
Lordship, in without having inspection, Milord,
That is not the law. Purpose is that you have to file a repairing application along with Order 39 Rule 7. Without
Lordship,
filing a
I
repairing
made a
application,
prayer.
because the purpose, what is the purpose for that?
Lordship, I have made a prayer also in my application that I am reading, Milord. Prayer the considering the communication.
What is the stage of the suit?
Lordship, evidence not yet completed, Milord. Till today, evidence not yet completed.
No. Whose evidence has started? Plaintiff's evidence completed?
No, Milord. Nothing started.
You are the plaintiff.
Lordship.
You are the plaintiff. What is the suit for?
Lordship, suit for declaration for Milord. Plaintiff is the Lordship. 1 minute. Milord, plaintiff is the status of the plaintiff is the occupier, Milord, and since 19 years, Milord, petitioner is staying over there, and that possession under the petitioner, Milord, has not been any evicted in since long without any due process of law, Milord, and Milord, anyone from the suit premises, Milord, having one room construction, Milord, that is prepared by Kacha house, that is, and photograph has been attached also. Milord, on earlier occasion, Milord, I placed one application for inspection that has been not considered due to having some clerical mistake that has been not placed by me. And thereafter, Milord, I filed that application for inspection, local inspection to get the repair of the house. My simple prayer is that kindly to submit the
Affidavit of service filed in court today is taken on record. First of the learned advocate appealing for the petitioner submits that the opposite party has been duly served. First up, this application under Article 227 of the Constitution of India is at the instance of the plaintiff praying for a direction, and is directed against an order dated 26th of April 2025, passed by the learned Civil Judge Junior Division, Second Court at Alipur, in title suit number 432 of 2021. First up, by the order impugned the application under Order 39 Rule 7 of the Code of Civil Procedure for holding local inspection stood rejected. First up, it has been stated in the said application that the suit property is in dilapidated condition and the same requires immediate repairs. First up, for the purpose of bringing the clear picture of the suit property before the learned trial judge, the petitioner filed the application for local inspection. First up, this court is of the considered view that local inspection in aid of the local inspection is necessary for the purpose of bringing the clear picture before the court as to whether there is any necessity to effect repairs of the suit property. First up, the learned trial judge rejected the said application only on the ground that it will have the effect of collection of evidence. First up, though some amount of collection of evidence, it is well settled that you are appearing for the opposite party in this matter. Yes, what do you have to say?
Missed the brief, my lord.
Repairing application, the local inspection in aid of repairing. I am allowing the local inspection. Every non-appears to na likhe, ota kore din the heart Mr. Chatterjee learned advocate for the opposite party on such submission, ঠিক আছে? পিটিশনের পরে এটা করে দেবেন। তারপরে লিখে দিন পিটিশন সাবমিশন রেকর্ড করেছে কি একটু দেখুন তো। তারপরে তাহলে তাহলে একটা দুটো প্যারাগ্রাফ আমি বলে দিচ্ছি পরে। এখানে কোন পর্যন্ত আছে আগে? হ্যাঁ, the learned advocate appearing for the petitioner submits that the application for local inspection was filed in order to bring the clear picture of the suit property before the learned trial judge. First up, the learned advocate appearing for the opposite party submits that the suit property does not require any repairing work. ঠিক আছে? এবারে যেখানে হচ্ছিল কি, it is well settled that an application that it is well settled that local inspection is necessary for the purpose of ascertaining as to whether the suit property requires any repairs. For such reason, this court is inclined to set aside the impugned order and allow the application for local inspection. First up, accordingly, the impugned order is set aside. First up, the application for local inspection, the application under Order 13 Rule 7 of the Code of Civil Procedure stands allowed. The learned trial judge is directed to appoint a commissioner for holding local inspection on the points as mentioned in the schedule of the application under Order 39 Rule 7 of the Code. There shall be however no order is taken. Call the next matter. Same order adjourned. Next. Yes, 1587. Same order adjourned. Next. আরো দুটো আছে, আরো তিনটে আছে, 455, 109. Same order adjourned. Next.
Actually, we appear for the defendant number 1 in this matter.
Opposite party or the petitioner?
Opposite party, Lordship.
Who is the petitioner?
Mr. Asim Raut is appearing on behalf of the petitioner, my lord. Last occasion also they have not appeared. My lord, there is subsequent development in the suit that the final decree of the suit passed by the
court. You are not affected. Any order is there?
Yes, my lord. Passed final passed by the court.
All right. None appears
in June 2025.
None appears for the petitioner at the time of call. No accommodation has been sought for either. The opposite party is represented by the learned advocate. First of the learned advocate for the opposite party is directed to serve a notice upon the learned advocate for the petitioner, intimating that this matter shall appear in the list. This matter shall appear in the list under the heading.
Become infectious in view of the final degree passed by this court.
Final degree has been passed.
Yes, yes, that
was the order under challenge.
Partition commissioner's order.
Order of appointment of acceptance of partition commission report.
Yes, challenging that a first appeal was filed.
Yes. Your lordship kindly. Only in respect of the law element, your lordship kindly look into the order dated 13 January 2025. দিয়েছেন
No, no, they are challenging this.
Yes, lot allotment.
Yes. They are entitled to challenge that.
That was finally decided in the final decree. What's remaining in the revision application? It's became infectious.
None appears for the petitioner at the time of call. No opposite party. None appears for the petitioner. The opposite party is represented by the learned advocate for the opposite party is represented by its learned advocate. He submits that the petitioner is not appearing, is intentionally not appearing before this court. First up, in view thereof, CO number such and such stands dismissed for report.
Well, let the final decree be kept on record, my lord. We already handed over to your lordship.
Not, I have only dismissed for default, yes. Next. Take it back, take it back. Same order adjourned, next. ওটা হয়ে গেছে? Yes. Yes, yes, Mr. Bhagat.
Item number
68
Milord.
but they are not willing to come, my lord. They are not willing to come now. Kindly take it tomorrow, my lord, so that I can give notice only.
Mr. Bhagat, tomorrow is difficult because on all days are fixed matters.
Then
For this are fixed from 4 p.m. From 3 p.m. another group was there. Tomorrow many matters are fixed.
then
May not be
day after tomorrow, my lord.
Let me check up my diary. I will
I'm giving
consider.
the number so that it may appear on Friday. Because
Let me check up the dates, Mr.
What is happening? I'm just the water is percolating from the roof. They cannot, my lord, open the soap. 4 soaps.
He was his junior. He was here. He did not appear.
Probably missed.
No, he was present when the other side was there.
When no, he did not turn up by that time.
Lordship,
Kindly take it on Friday.
Friday, Mr. Bhagat, there are other matters fixed. Up to 24th of July.
Anytime.
Up to 24th of July, all matters, dates have been fixed. Upgraded matters.
24th July.
Yes.
Then I have to wait.
In all matters, you have seen some matters of the combined list and supplementary list. I am fixing. I am giving dates.
On the previous occasion, they did not appear. We appeared. So
yes,
chance may be given tomorrow or day after tomorrow.
Let me see. I will consider. I will fix a date, but
the
may not be tomorrow. No, it is only those.
numbers.
আচ্ছা ওই ম্যাটার গুলো যেগুলো বলছেন সেইগুলো শুধু রেখে দেবেন আর অন্যগুলো তো
4টে নাম্বার দিয়েছি। 4টে নাম্বার দিলাম পেয়েছেন?
এই যেগুলো দিচ্ছেন সেগুলো রেখে দেবেন। আজগুলো সব একদম মান্থলি লিস্টে যেরকম জায়গা আছে সেরকম পাঠিয়ে দেবেন। ফুটারে না কালকে নয় রেখে দিন ফুটারে তারপর দেখে নেন।
Lordship, item number 1568 Milord, if possible, upload the order, Milord.
Yes.
Because I am out of the time, I'm going. If possible.
Any other?
The next daily list 48. Daily list item number 48.
Daily list item number 48.
47 has reached.
48, there is no caveat. All right, call 48.
I have challenged the rejection order of my 51 application, which I have filed. Initially, I have filed, but I didn't raise it. But subsequently, after getting preliminary decree, my lord, I filed another 161 application for police help because it's a partition suit. But what plaintiff, opposite party number 1, because my lord, petitioner, opposite party number 2 and 3 jointly filed the partition suit against the opposite party number 1. Now, my lord, he admitted the share, 1/4 share I have over there. Accordingly, preliminary decree passed. And my lord, thereafter, he preferred an appeal, challenging the preliminary decree. Now, my lord, my 161 application has been turned down on the ground that I didn't specifically state that when I was disqualified. But my lord, I have annexed my application of 151 where I specifically stated that he violated the injunction order. Even at the stage of my lord, adding preliminary degree, the learned court below restrained him, alienated.
Which portion of the impugned order you are challenging? Last portion.
Yes, my lord.
Last portion. Place where is the application under 151?
My lord, I have annexed that.
Page.
Page 114.
114.
Just prior to the certificate. And 115 is the relevant paragraph number 3 and 4. In Honorable High Court, they gave an undertaking, yes, they did not induct any tenant over the property. On basis of that, my revisional application got dismissed on an earlier point of time. During deposition, they admitted that he inducted tenant over there. Then I preferred 151, that got rejected because according to the learned court below, I didn't specifically stated that when he inducted the, my lord, tenant. Partition suit, my lord, he admitted my share over there. Paragraph 4 is, my lord, I have said. And that injunction, my lord, not even an absolute injunction. During After my lord preliminary decree, the learned court below restrain him from alienating the property. I have annexed the preliminary decree as well. Just because my lord he preferred an appeal, I paid commissioner fees, but suit is not proceeding.
Where is the order dated 29th of July 2024? July 2024. You have paid for implementation of that order. Where is that order? 29th of July 2024.
So that is preliminary. The operative part is my lord at page 63.
Page
63. Operative part.
No, 29th of July 2024. Where is that?
My lord, page 56 is the start.
Page 56.
It does start because they when the my lord TP has the judgment has been passed. And
yes.
Operative part is page 64. The instance should be at the same degree. The different, but without God. 1/3 share and 1/4 share.
Yes, yes.
Then my lord stated the parties are directly paying partisan. Then my lord second paragraph. Parties are further directed to maintain status quo in the property regarding nature, character, and existing position till completion of the actual party. And my lord, in evidence, he admitted that he inducted it.
Under 151, what can be done? If there is violation, you file an appropriate application.
Order 39 rule 2A, I can't.
Why?
Because my lord, it's a preliminary decree, my lord.
So what?
Because he preferred an appeal. My suit is not proceeding. I have bring the my lord last.
151, what can be done?
My lord, I am asking that I should be that order should be implemented.
How? How? Implemented by whom? Police.
By police, because
So how the police will know in which person you are in possession?
by 151, my lord,
Yes.
put below and direct the police that to ensure.
How the police will ensure as to who was in possession in which portion? Ashun, this application under Article 227.
He is not.
Police cannot decide as to who is in possession of which portion.
My lord, they have admitted that I have 1/4 share or 3/4 share.
Yes, take appropriate steps. This application under Article 2.
Filed, my lord, suit court is not proceeding.
That is a different thing altogether.
Well,
This
that is
application.
exactly, I mean, my lord, may I one direction that the my lord appeal should be dismissed within a reasonable time.
This application under Article 227. This application under Article 227 of the Constitution of India is at the instance of the plaintiff and is directed against an order being number 50 dated February 1, 2025, passed by the Learned Civil Judge, Senior Division, Kharagpur District, Paschim Medinipur, entitled suit number 278 of 2020. So by the order impugned the application under section 151 of the Code of Civil Procedure, praying for police help was stood rejected. So the learned advocate appearing for the petitioner submits that the preliminary decree was passed on 29th of July 2024, thereby declaring the shares of the party, and the parties were directed to maintain status quo in the suit property regarding nature, character, and existing possession till completion of the actual partition of the suit property by metes and bounds, and by drawing up final decree accordingly. So the petitioner, the learned advocate appearing for the petitioner submits that in violation of the preliminary decree, the petitioner, the opposite party herein is restraining the petitioner from entering into the suit property. For such reason, the petitioner has filed an application under section 151 of the Code of Civil Procedure. First up, the police cannot decide the issue as to possession. First up, the learned trial judge, by the preliminary decree, the parties were directed to maintain existing possession. First up, unless in the preliminary decree, it has not been stated as to, in the preliminary decree, only the shares of the parties have been declared. First up, nothing is on record to indicate that the plaintiff, that the petitioner is in possession of which portion of this suit property. First up, paragraph, for such reason, this court finds that the learned trial judge was right in rejecting the application under section 151 of the Code of Civil Procedure. So this court does not incline, this court is not inclined to entertain the same. Accordingly, CEO number such and such stands dismissed. There shall be, however, no order as to cause.
My lord, so far as appeal, my lord,
My lord, may I have your lordship's
condition suit, my lord, they will drag the.
Yes.
Lord, may I have your lordship's leave to mention item number 1600 of monthly list. My lord, the temporary injunction has been stayed in miss appeal, my lord, and my lord, they are raising construction, my lord. They have come.
Why did you not mention in the morning?
Lord, I have mentioned it several times, my lord, before, my lord. Today, my lord, I have got the information that they have come to the premises and, my lord, they are raising the construction, my lord. If not, kindly, my lord, includes this matter, my lord.
If you have mentioned earlier, if you have mentioned the urgency, it was
Yes, Lord, I have-
considered.
I have
Please check up what is the endorsement.
As your lordship, please. Sure.